and Shri Mohit Mathur sir to please come on dais. थैंक यू मैम, थैंक यू सर। नमस्कार, आप सभी का आज के विशेष आयोजन के अवसर पर स्वागत एवं हार्दिक अभिनंदन। रिस्पेक्टेड प्रोफेसर अंजुवली टिक्कू मैम, हेड एंड डीन फैकल्टी ऑफ लॉ, श्री मोहित माथुर जी सीनियर एडवोकेट, प्रोफेसर अलका चावला मैम पीआईसी सीएलसी, प्रोफेसर अजरीबी मैम, all faculty present here, staff of university and my dear students. I am on my behalf, on behalf of Faculty of Law and on behalf of University of Delhi, extend a very warm welcome to you for this very special occasion. Today, we are celebrating a special triangle of three things. Number one, firstly, we are celebrating the centenary year of the Faculty of Law. Secondly, we are celebrating 75 years of our Constitution. And thirdly, and more particularly today, enactment of 3 new laws, which are Indian laws. So today, as we all know that the new criminal laws have been enacted with the Bharatiya conception. As you are aware that we had criminal laws, basic criminal laws from the colonial period, which are redundant, most of the provisions. That is why the Parliament has decided to enact 3 new laws. So today we are celebrating that enactment of 3 laws. Now, in order to honor and welcome our 3 laws, in today's program, we are going to conduct 3 sessions. The first session will be on the BNS, that is the replacement for the IPC, Bharatiya Nyaya Sanhita. Second session will be regarding the replacement of CRPC, Bharatiya Nagarik Suraksha Sanhita. And the third session will be replacement for the Evidence Act, Bharatiya Sakshya Adhiniyam. So in the first session, we have our honorable guest, our host as well, Professor Tikku ma'am and Shri Mohit Mathur sir, who are the expert on the area. So I would like to briefly introduce Shri Mathur sir. Mr. Mathur is a senior advocate and the prominent criminal lawyer in the country. He has been president of Delhi High Court Bar Association since 2019. And he has taken the legacy of his father and his grandfather. Sir has begun his career under the guidance of Attorney General for India, Mr. G. Ramaswamy, and after that he has started his practice. Sir has been part of many of the prominent cases which highlighted the country. Some of them are as follows, like the Jain Hawala case, anti-Sikh riots case, Augusta Westland case, Bofors case, Coal block case, 2G Spectrum case, BMW hit and run case, INX media case, Personal Point, triple murder case, PGF PSCL scam case, Singh Brothers scam case, Bhushan Steel, SFIO prosecution 2020 riots case, Delhi liquor excise policy case, and has constantly delivered tangible and effective relief for the his counsels, his clients. So sir has done a lot of services for the young advocates as well. He is keen in doing help to the young advocates and guiding them. So with this brief introduction, I would like to request Professor Anjuvali Tikku ma'am to kindly honor our guest and felicitate him. Thank you, ma'am. Now I request Professor Avekta to kindly honor ma'am, felicitate her. Thank you, Professor Avekta. Now we begin the first session. I request our Dean ma'am to give the welcome address and introduction about the 3 laws, why we have the new 3 laws. As paucity of time, and everybody knows ma'am is our own, so I won't take much time to introduce her. As we all know that she is the expert of criminal law, and I am honored that I am also her student of criminal law. So ma'am has expertise in this area. Ma'am has been, thank you.
नमस्कार, आप सभी का इस मौके पे स्वागत है, अभिनंदन है। आलोक ने सही कहा, सही नहीं कहा, मैं सही नहीं कहूँगी। आलोक ने जो भी कहा, आई एम हम्बल्ड बाय योर स्टेटमेंट दैट यू हैव बीन माय स्टूडेंट, बट मुझे नहीं पता, मैं अगर कह दूँ मोहित मेरे फर्स्ट बैच में थे, दैट इज़ व्हाट ही वाज सेइंग कि अंकिता ने बोला, तो ही सेड दैट इवन आई हैव बीन योर स्टूडेंट in tax law, not in criminal law. So it was only that first year that I had taxation paper. That shows that what kind of expertise Mohit happens to have over a period of time, and he happens to have a legacy also in criminal law specifically. So when I reached out to him and he was generous enough that okay, I'll confirm once I'm back. So not getting into all this, keeping in mind that we have got lesser time, I decided that I would be only talking about theoretically the background as to why there was a need felt to shift from our old criminal laws, which happen to deal with the basic, specific, substantive as well as procedural laws, and now that we have implemented today, what is so special that we wanted to have a seminar today, keeping in mind that we are right in the middle of our admissions, examinations, and many things happening, that the students are still busy. But yes, thank you very much for those of you who have still participated, despite that we happen to have our exams from 4th of July. So first of all, welcome Mohit back to Faculty of Law, now on the other side of the podium, and as guest speaker. Having made a mark and having been recognized as senior advocate, we all are aware, once you happen to just go to Google and just type his name, you will find that there is that list of activities that he is recognized for and in which he has involved. So being socially relevant is what Mohit stands for, and true to his name, that the moment you approach him, he just says, okay, hang on, bear with me, I'll come back to you. So thank you very much, Mohit, on that count. When we talk, and yes, of course, my dear colleagues, there's the Dean Academics, Professor Ratnabali, Professor Rajni Abi, Proctor, Professor Alka Chawla, Professor Anupam Jha, my colleagues, important significant ones along with L. Pushp Kumar, who are holding the 3 centers together, rather 4 centers together. When we talk about criminal laws, irrespective of the fact whether it is our area of interest or not, we happen to run into these laws by default. At some time it is a traffic light violation, at other point of time my neighbor happens to have any difficulty. So each one of us, irrespective of the fact whether we belong to law or not, need criminal laws, and we need to acquaint ourselves with that. Keeping that in mind, what I think is important for us to understand at this point of time is that we begin learning the differences between what we happen to have in the form of old laws and what is it that has been incorporated now. First thing that we all must have heard over a period of say last 6 months, that we say भारतीय न्याय संहिता. ऐसा क्या है कि बदल गया है? नाम ही तो बदला है, content थोड़ी बदला है. But then I have got a different perspective in that, and it's, for me, the moment we say न्याय, we are not anymore talking about penalty. We are not focusing on that. We are instead trying to find out what is the best thing to do, what is the right thing to do. And in that sense and on those lines, the approach of our laws being implemented would certainly come up with a shift, with a change in our approach, so that we also need to understand that we are not anymore talking about penalties. We are not finding fault with people, but yes, if somebody happens to commit a wrong, gets entangled into a crime, what we need to do. And from that standpoint, the moment we talk about nyay, justice, we are trying to find out a resolution. That's where you must have heard of that from deterrence, from retribution, we have moved on to the approach of restoration. So that is where we are shifting away from that attitude of colonial masters that they had to subjugate the local population, so that there was that threat and fear of punishment. So when we talk about punishment, even in new laws we would realize that there is slight shift. So in not only imprisonments, but we have brought in that notion of community service. And when we talk about community service, it is you and me together. So having committed a wrong, having harmed you, injured you, it's my responsibility to rise to the occasion and put you back into the same state, so that it is not a disconnect and a disintegration of the society in the form of the accused and the victim and the society, so that we are only focused about accused, but we are also talking about the victim, so that it's the responsibility not only of the state, but also of the accused to do something positive. Jo galat ho, individual behind the bars, and we are feeling happy that yes, everything has been sorted out. Yes, the person undergoes punishment, but once he comes back to the society, what happens thereafter? Are we prepared to interact with that individual who has apparently and supposedly undergone his quantum of punishment? I'm sure none of us are inclined and would like to talk to and forget about interact and integrate those people within our close-knit circle. So here is a shift wherein we say, and we are talking about people being involved in reintegration of the society, which also incidentally happens to touch upon the restorative approach, which of late we are talking about with all kinds of wrongs, primarily on account of the fact that if we start labeling individuals as criminals, the moment we target them, the moment we label them, the scope of reintegration is lost. The scope of collectivity is lost. The scope and understanding of a social unit wherein we reach out to each and every other is lost. So community service has been incorporated as an alternative form of punishment, which is certainly a positive step. Along with that, we also understand that we generally, when we talk about criminal laws, we had the punishments on the lines that punishment may be awarded up to a maximum. So there was no minimum laid down generally, excepting the provision of rape in section 375. Now we realize that punishments have got a slight shift in specific offenses. So when we talk about heinous offenses, it very clearly and categorically says minimum of 7 years. Maximum can be life imprisonment, and here is an important aspect of imprisonment, that life imprisonment has been defined as up to the last breath of the individual. So it's not just 20 years or 14 years. And we do have sexual offenses, offenses against women, when we find such kind of clarity which was not there. Another point that I would like to highlight, which happens to be concerned with each one of us, and we happen to come across those kinds of offenses, hit and run cases, people who get killed. And we do have n number of cases pertaining to celebrities wherein there has been a tug of war in the highest courts as to whether this is murder or this is death caused by negligence, so that if we get into the actual implications, if there is a case of murder established, then life imprisonment or death sentence can be awarded, does get awarded. But if it is only a matter of causing death by negligence, it was maximum 2 years imprisonment. And there had been huge debate, conversations and resentment among people that this is not justified. A person loses his life, but because it gets labeled as, it gets recognized as only death caused by negligence, any wrongdoer, somebody who is belonging to the privileged category, certainly when we are saying hit and run case, we are talking about generally motor vehicle accidents. So somebody who happens that privilege of riding a vehicle gets away with the killing of a human being by merely just 2 years of imprisonment. And there is no need to talk about specific illustrations. You name it and you have it. All those bigwigs, celebrities having got their name here and there recognized as role models, against them we happen to know that there are cases of causing death by negligence and they have got away with least possible punishment. So this is a welcome change wherein we find that with reference to even causing death by negligence, it is recognized as a specific offense with enhanced punishment. So it's not just 2 years imprisonment. That's a welcome change. Beyond that, another aspect that needs somewhere recognition and somewhere in acquaintances, that we have heard a lot about sedition. And this is something which has been in the media, this has been in the news, whether we should continue with section 124 IPC, 124A IPC, which talks about sedition, or this is a colonial provision and a rule law and we need to do away with. Now, the government of India has played very safely. They have removed that word sedition, 124A, but they have by a side window brought in, kept the content of sedition. We have got, say, organized crime, and when we talk about organized crime, I am happy to inform you that there are major changes, major offenses brought in which are talking about organized crime, specifically wherein rackets are there. So if we talk about, say, begging, if we talk about human trafficking, if we talk about, say, offenses against women who are being put into prostitution, so there is enhanced punishment. So that is again a separate set of offenses which is dealing with sexual offenses, wherein we have got a significant change that we are not anymore talking about only man and woman throughout the language of IPC. We have also recognized the notion of gender. So the third gender has been recognized, which invariably was a problem issue whenever we said it is he and she. A man includes a woman, and invariably I would react saying that she includes he, not he includes she. So that's just a gender perspective. On a lighter note, what we do appreciate is that new Bharatiya Nyaya Sanhita is a move towards doing something positively, constructively when we are talking about wrongs. So compensation also is recognized, because compensation as it is thought to be something belonging to the domain of civil liability, but it has been integrated into criminal liability also, so that the concept of fine brings in the concept of compensation also alongside fine. So these are few pointers that I just wanted to highlight, and I would certainly would wish to learn from Mohit, who is an expert from the field, and give us an idea with some interlinkages that how these changes can possibly have an implication, because it is too premature to conclude as to whether these laws are good enough, sufficient enough. That's where we have put the title, The Way Forward. And we look forward to you, Mohit, for listening to what are your observations from the field as to what can we possibly expect, and what are the areas that we need to keep track on, that yes, next time when we happen to put our heads together, this is something we need to discuss and deliberate upon. Thank you very much, Alok, for giving me that opportunity to just introduce the topic. Thank you.
Thank you, ma'am, for wonderful introduction and the major changes which the new law has done. Briefly, ma'am has discussed regarding the introduction of some new provisions and deletion of some of the provisions. Now, I would like to request our esteemed speaker, Shri Mohit Mathur ji, to come and enlighten us. Thank you, sir.
Good afternoon, everyone. Professor Anju Ali Tikku, Dean, Professor Alok Sharma ji, Alka Chawla ji, Rajni Abbi ji, these are the few names and people I recognize. All the faculty, members, ladies and gentlemen. It in fact always gives immense pleasure to come back to your own alma mater, and very kind words have been spoken about me. But ma'am, I think after students like us, you also thought it's better to shift to criminal law than keep on taxation. We were in fact a very dreadful group, and taxation used to be one of the optional subjects and not the mandatory subjects at that time. I don't know how the curriculum now figures. Much has been spoken about these three laws ever since they have been notified to be implemented from today. As defense counsels, we generally try to rip into each section to see whether it helps us or it's going to harm us, because 90% of our practice is in the area of defense of an accused. So our perspectives may be slightly leaning towards the defense side. So kindly excuse me for that. But undoubtedly, it was a gargantuan task to overhaul these three laws. Though I may not be agreeing with many, because I feel that Parliament was wise enough to not touch and change it merely because it had colonial impact or it had colonial color. They were wise enough to pick out what is there and which has been going fine, be it 140 years, 160 years, or the CRPC, which had actually undergone an overhaul after 75 years from 1898 to 1973, and then again now after 50 years. Procedurally, and as far as the Evidence Act is concerned, it's more to do with technology being infused into it. But when it comes to IPC, the Bharatiya Nyaya Sanhita, the choice of the words, Bharatiya to make it more indigenous, Nyaya to bring in the concept of justice rather than the penalty, which rightly said was a colonial mindset. There were other aspects also of the colonial mindset which the Parliament recognized. And in fact, a number of issues which had been cropping up in the past couple of decades have been addressed more in the procedural law, the BNSS. As far as BNS is concerned, the Bharatiya Nyaya Sanhita, for short, is the aspect of understanding that those penalties which were simple fines of 100 rupees, 50 rupees, were not even a slap on the wrist. They were being used by people कि चलो चलता है कोई बात नहीं 500 रुपए दिए आगे बढ़ो. At least that has been now brought on record in terms at par with what today's lifestyle is. The penalty should be pinching also, besides the theories of reformation, etc. To that extent, the new law takes care of much. But as Professor Anju Wali said, that these laws touch every Indian. They permeate into our lives on a daily basis. And therefore, whether we like it or not, we are impacted by it. So just to give a brief, and I am saying so brief once over again, for the sole reason that the time limit which is given to me does not even allow me to address and enumerate each of the portions which actually impact. And just to start with, please understand, while 20 new offenses have been added, 19 stand deleted. And one was mentioned by ma'am as 124 capital A. And she rightly said, by the sidewind, you have brought in 152, which is based on the concept of deshdroh, treason, and not sedition. It's pretty diluted, ma'am. Since we have to take care of the accused, we try to judge and analyze these provisions on that basis. That fortunately, the much complaint about sedition being used against the common masses may not be possible with treason. Because this has to be with the sovereignty and integrity of the nation that it is now coupled with. But something which as faculty and as students of law and all of us together need to understand is, we have introduced two very, very important special statute sections into the general law of BNS. One being the offense of organized crime under 111, and second being 113, the Terrorist Act. Now both are generally taken care by the special statutes. One in Delhi by MCOCA, the Maharashtra Control of Organized Crimes Act, as extended to Delhi. There are similar organized crime statutes in different states. So now introducing it in the general law impacts many people. Though the motive may be to curb these rackets, but there's an area of concern, and that area of concern in organized crime is in the petty organized crime. When you leave organized crime only to the organized crime where under the Organized Crimes Acts, the statutes, special statutes, used to be the bigger rackets, the bigger gangs, because the words used are syndicate in the organized crime. Being a member of the gang is now what is now used under the general law. You are now adding the racket business to even smaller crimes when you bring it under petty organized crime. Unfortunately, what the parliament missed out and will need intervention and interpretations will be the word used, any other similar criminal act. Now, the sections and the offenses which are quoted under the petty organized crime are not which read on one kind of a category. Betting, black marketing of tickets, cheating, they don't go together. In one, there is an inducement, and the other, there is a playing on the gambling instinct, where a person consciously enters into that transaction. Whereas, under cheating, you are being deceived and induced under that deception. So they are not two similar acts. A black marketing of ticket has nothing to do with any other similar criminal act. Now, probably it's not happily drafted, but therefore it leaves a lot of scope for interpretation. And it will require the judiciary to step in, lawyers and academicians to start voicing their concerns that there has to be some kind of a protocol, some kind of a understanding of the machinery, the state machinery, to include it to limited things only. Or there should be a categorization as far as the sentencing is concerned. There has to be some yardstick. Otherwise, any other similar criminal act could be sweeping. It's a sweeping statement. So that's one area of concern which I thought must excite the attention of everyone. Another thing which I have been speaking in different forums is the preamble of both the Bharatiya Nyaya Sanhita as well as Nagrik Suraksha Sanhita is an act to consolidate and amend the laws. Now, I don't want to take coals to Newcastle. All the respected faculty members know consolidating act has to be a consolidation of all the existing acts into one. Unfortunately, 111, the Terrorist Act section, after the 7 clauses of duplicating what was section 15 under UAPA 1967, at the end says, a superintendent of police shall decide whether to register the case under UAPA or under this code, Sanhita. Now, if you are leaving it open to a superintendent of police, what kind of consolidation has happened? Either it should be here or it would be there. Now, you are making this discretion available to a superintendent of police. And that has to be done before registration, with no guiding principles as to how he will decide. And why I say so is, though that is not the subject today, for me, probably the next speakers will take care. UAPA, as a special law, has twin conditions on bail, has a specific procedure for investigation. If you want to make it tough for a person to come in, to get out of the act, you will invoke UAPA. Because BNSS, the Bharatiya Nagrik Suraksha Sanhita, does not distinguish between a terrorist act as it does about the other offenses. It does not put any restriction on a terrorist act. So if I want that the investigative procedure to be controlled, I will go under BNS. If I want the man to remain behind the bars, I will go by UAPA. Now that cannot be permitted if it's an act to consolidate. That's something which will be again debatable, and since we are only at the threshold and we are only starting, this will be an area of concern. And you ma'am mentioned about hit and run cases. Rightly so. The hit and run cases, the sentences used to be less and it used to be bailable because only Britishers had the cars. And they were the employers. So it's a death by rash and negligent act, not just hit and run. Motor vehicles is just one part of 304 capital A, as it stood till yesterday. But today, what we see in 106 of the new code also includes medical negligence. And when it includes medical negligence, it overlooks a judgment of the Supreme Court in Jacob Matthews, which categorically said that you will not register a case of medical negligence unless and until a report by a board of doctors with one specialist of that field and one head of department of the general and of a government hospital. So this probably was lost sight, and therefore introducing medical negligence in BNS may be in the teeth of the judgment some problem area. And medical negligence as well as Rash and Negligent Act does not leave any discretion now, because it's rigorous imprisonment and fine. So it is not that or fine thing which ma'am was trying to say, that people with means could get away with lesser punishment. So now they have to suffer some imprisonment mandatorily. That's since it includes medical negligence, and there's an aggravated version in clause 2 of 106, which takes it to 10 years that if you do not report it to but that's specific to hit and run, that unless and until you report the accident to the nearest magistrate or the police. There is one very important aspect which has actually happened, which perhaps in our effort to see the larger things we forget, is the extraterritorial application of BNS. Today, the definition of abetment includes cross-border abetment as well. And this is what academicians had been speaking, prosecutors had been arguing, and we, trying to protect our accused, would always say that the IPC lacked territorial application. Adolf Eichmann case of Israel is a commonly quoted on the extra-border terrorism, cross-border terrorism and cross-border influencing, was on the basis that people sitting outside are today unnecessarily pumping venom through social media and through their outreach to the people here, and they are creating a problem. So to cover that, the cross-border application and abetment has been included in the extraterritorial application of the BNS, which is something very, very welcome, and in fact would help the agencies to rope in people who are otherwise not accessible. Something which will be a subject of the BNSS is, in such cases, trial by in absentia under section 356 of BNSS, which whoever is the speaker will take care. The trial in absentia used to be only to a limit, now it has gone to even beyond judgment. So this extraterritorial application actually has to be coupled with that I am not able to catch hold of that person, that fugitive, but I will conduct a trial based on the material which is available here. That's something which is a very welcome step. Mob lynching is again a concept which Parliament was cautious enough to include it in murder. Punishment of murder as death and life imprisonment, 103 of the BNS now includes mob lynching as well. And this, the reason why, though I couldn't catch hold of the debates, I could not lay my hands on any of the discussions, but during my discussions with some of the people who were in the panel was that the common argument at the time of murder is there was no motive. He had no animus. So removing that personal animus concept by adding hatred on the basis of caste, creed, color, sex, religion, anything. So all that is now assimilated, and lynching has also been raised to the level of murder. Now, snatching is another part which under section 304, if you read, snatching is an exaggerated punishment of theft. Because snatching, if anyone has ever been to the police stations, there is a big chart there where they put in the offenses which relate to their local ilaka law and order situation. And ma'am would know it better, having been with the law authorities, that snatching gives an idea of the local law and order situation. And snatching, if it is left to the punishment of theft, it would be sentence of imprisonment or fine, whereas now it is and fine. So you can't get away with just the thing. Snatching has been specifically carved out as a special portion. Now, but one area again of concern to all of us. The ladies may not find it an area of concern, but men may. And that is an offense under section 69, which has been added. It's carved out as sexual intercourse by deceitful means. Though the parliamentarians have written, the legislature has already written, it is not rape otherwise. But if it is by deceitful means, if this intercourse has been done, it is punishable with such and such imprisonment. Now, unfortunately, the scope and the arguments which used to be generally for promise to marry, that this rape has been performed under that promise to marry, this has now been enlarged to promise to do anything, providing employment, what used to be the casting couches, what it can be for even promotion. It is beyond just marriage. So any such promise which would be any deceit, personally, in my opinion, consent obtained by deceit is otherwise also not consent. So in my humble view, this section would have been better not to have introduced this section, because this is now going to add more to vexatious proceedings, which we have seen in the past, that when you try to bring in something new, which is open-ended, and it will take some time before some kind of protocol, some kind of interpretation, some judgments will come to keep the penal statute stricter in interpretation. So it leaves a very, very wide area open, and therefore probably a little dangerous in its working. Something, ma'am, on the punishment side, what you mentioned, though our high courts across the country have been giving judgments while quashing the petty offenses, or even those which have no impact to the society as such, or doesn't impact the people, they would add planting of trees or other community services. Even remedial classes used to be, if the accused was anything to do with teaching, they would add remedial classes as a punishment and quash the proceedings. Community service is added, albeit with only 6 offenses, which is still less according to me, because community service could have been introduced and allowed to be given in more number of offenses, especially where the gravamen is lesser. If it's only 3 years or less than 3 years or something like that, it could have been, and it does need improvisation on that regard. And I personally feel the efforts have been made, but those efforts, how they are interpreted finally with the judgments coming in, and the judgments will have to interpret what is being provided to the people, whether the new sections give the impact as is desired, because the intention of the Parliament is paramount. So since I was told to keep myself in check, not get swayed by the fact that I am before a lovely audience and I should not start spending more time speaking. Thank you very much for this opportunity, and as citizens of this country, it's our bounden duty to not just follow the law, but to get a meaningful thing out of this law which has been given to us. We need to follow it. The parliamentarians' intentions will have to be judged, interpreted, and let's see how things turn up. We still are a young country. Thank you very much.
Thank you, sir, for giving the idea regarding the concerns of the accused person, as many provisions have taken from like the Organized Crime and Terrorist Act from the UAPA. So definitely concerns are there for the accused person, but on the other hand, you have also highlighted the areas which are good for the common man, and some provisions are well drafted and included. Thank you, sir, for giving this idea to us. So we can now have 1-2 questions if you have any. Everything is so comprehensive. Okay. I'm not able to see. Please stand up. Yes. Sachin, आगे आ जाओ. बढ़ा दिया है. बढ़ा दिया है.
वैसे ये नेक्स्ट स्पीकर का है BNSS, but just let me answer you. Again, that section 187, देख लेना. It is yet to be interpreted, because what they have done is they have removed the proviso to section 167(2) and now made it as a section itself, subsection, as section 187(3). But what you are talking of, the danger area, is that it's not that it is 90 days. It's only 40 and 60 days in cases of 60 days and 90 days respectively. However, the only area of concern is removal of the words other than police custody. Now the dangerous area is if you interpret removal of the words other than police custody, meaning that every 15 days can be given to police for 40 days or 60 days as the case may be, it is draconian. However, one will have to interpret it, and you can ask the person, the speaker, whoever is the learned speaker for BNSS, there is a provision that you will not deny bail on the ground that the police custody is yet to be taken. So once that is to be interpreted, then we will have to interpret the words 15 days as a whole as total 15 days. Otherwise, it is in teeth of CBI versus Anupam J. Kulkarni, 1992 Supreme Court. So please check it. It's not that you go up to custody for 90 days. It's 40 days and 60 days, but it is actually splitting of the 15 days. So one has to interpret the words 15 days as a whole or in part for this purpose. Otherwise, the impact area has been removed, that other than police custody, which meant that beyond police 15 days, no police custody could be given. So that they removed, but it is not happily drafted. I'll say that again.
Thank you. Any other question on BNS only, please? We'll keep these questions for the next speaker. BNS, IPC का जो change हुआ है, कोई question है? Yes, please, quickly.
You heard Anju ma'am say that this is moving towards Nyay. So we are moving from retribution to reformation. And when you are moving to reformation, the community service as a punishment comes at the end of a trial. Sitting in rooms, we do not get the idea, but the agony which a person goes through at the time for trial also pushes him to sometimes really understand that he had done wrong. And when community service is given, it is not being given today. See, another aspect which obviously, because of time constraint, I did not say, gradation of punishment is also given under the BNS for the first time. It used to be under the specific laws that the first offender or a person with above the age of 60 will be given lesser sentence. A second time offender of the same thing will be given more. So community service comes in only in very, very petty offenses in the current BNS. When it is given as a sentencing procedure, if you understand the sentencing concept, the judge who sees the demeanor of the person, sees the various circumstances which mitigate the offense, the punishment, all those are taken into account when any of a sentence is given. What to talk of community service? Community service is a very new thing. And this has been introduced only because the high courts have been constantly telling that don't keep these offenses continuing. There is a concept of reflex repentance. If you read criminal jurisprudence, there is a concept of reflex repentance. I did an act, but I suddenly realized what I did was wrong, but I've already done it. Now, when I am repenting, you want to add salt to the wound? Fine, go ahead. But a judge may understand and look through it, but he doesn't have a discretion. So that discretion is today being given. So one has to understand we have changed as a society. We need to continue evolving as a society. So don't think that it is an impediment. It is not a mandatory thing that this offense will only be given with community service. No, there is none of the offenses. It is only as an option, as a lower sentence. So as a lower sentence, rather than sending him behind bars or asking him to pay a price as in money terms, he is asked to pay a price in social terms. By involving him with the society, there have been umpteen number of cases where when people who have some academic background are accused, they are told to carry out remedial classes. They are told to teach students. There have been people who have been asked to do car seva, either at the temple or a mosque or a gurdwara. And the last 5 years, you would have seen people planting trees. So all that is only to make you realize, but not to keep you behind bars. So it doesn't come in the way at all. And it is still a balancing thing. The judge has to balance it. And if at all there is anything wrong, then all of you have the chance to go to the higher court. If a magistrate or a session, it's only magistrate trial cases which are community service. So if a magistrate trial case, he has not done it rightly, it can be revised, it can be taken in appeal, it can be taken under 227 of the Constitution. So don't think it that if there is a liberal attitude is being shown, it means some kind of an impediment in the danda. No, that's not so.
Sir, I want to add, like already we have section 360 CRPC, till yesterday,
Probation.
and probation of offender act. Same thing used to happen even after 2 years punishment or 3 years, the judges, they used to send the people for the probation, not to the jail. That is the general practice. So it's already been.
Because probation, the section 360 would start instead of sentencing a person.
Yes, after sentence.
Now
yes.
that section 360 is no more.
Yes, now, sir, I don't remember the new section. Okay, so any other question on BNS? We can take one last. Yes, please.
if you have gone through the judgments of the Supreme Court long back has already shifted its focus from penal to reformation as much as possible, and they've used the word as far as practicable. Those are the languages used in the Supreme Court judgments. And mind you, most of it is old wine in a new bottle.
Yes.
So the interpretations will remain the same. See, we are only highlighting what is there as a change. But if you compare the two, actually, if what you feel is 358 sections in BNS from 511 IPC, what has happened is the first 50 sections, which were the definitions, have become now section 2.
Yes.
A simple section 2 is containing all the definitions, which is in all the post-independence statutes. You will find definition section including all that. So the interpretations will remain the same, the principles of interpretation will remain the same. Nothing changes. And fortunately, the Supreme Court has already taken the path of reformation, including in death sentences. They have converted death sentences, if it's gone beyond a particular period of time, to say that he's already suffered, so commute the death sentence into life. So we should not worry so much. We should not worry so much as if that some rock is going to fall or asteroid is going to fall. No. We are roughly with the same thing. It's only a few bits here and there which are causes of concern where open-ended situations are kept. Because open-ended situations have not been interpreted as yet. Well, probably it's a good time for lawyers. They'll start interpreting, they'll get more cases. So.
Okay, thank you, sir. Thank you for giving us this idea and reply the question. And I hope that many of us have clarified our doubts at what changes we have done and what new things have come. So nothing to worry, as I always reiterate the sentence which sir has mentioned whenever I go and take classes, old wine in a new bottle. So there is no need to worry. So almost everything is same except few changes here and there. So you are all advised to go through the BNS and the other laws to get the clarity. I thank you, sir, very, very much once again. Thank you. Thank you, ma'am.
We will enter into the second session. For that, I invite our respected resource persons, Senior Advocate Sanjay Jain sir and Professor Dr. Vageshwari Deswal ma'am. May I request the audience to be please seated. The second session will be a discussion on the Bharatiya Nagrik Suraksha Sanhita, BNSS, which until last night, midnight, June 30, 2024, was formally called the CRPC. With a contemporary outlook recognizing the need to include and imbibe with the evolving landscape of technology in investigation, trial, and court proceedings, to say the least, the new BNSS will certainly match up to our times. We are obliged and humble to have us join as resource persons for this session two very eminent personalities. Former senior advocate and former ASG at the Supreme Court of India, Sir Sanjay Jain, and Professor Dr. Vageshwari Deswal ma'am. Senior advocate Sanjay Jain sir's legal odyssey is one that I sincerely envy. Not just an alumnus of Law Center 1, sir was also the president of LC1 in the student union in the years 1984-85. As an independent candidate, which resonates his charming personality of leadership and discipline. In the year 1986 witnessed Sir embarking on his solo and independent legal practice, and he was quick to shift gears and adapt to a new era when the entry of MNCs in India. Sir's capabilities were highlighted through his list of clients, American Express and GE Capital, to name a few. 2001 to 2004, Sir Sanjay Jain served as the Central Government Standing Counsel in the Delhi High Court. Soon in 2005, December, the title of Senior Advocate was designated to Sir, which is well fitted. In 2014, Sir was appointed as the Additional Solicitor General at the Delhi High Court. In 2019, the appointment as the Additional Solicitor General for the Supreme Court pour in diverse cases in the field of taxation, bankruptcy, insolvency, land acquisition, high-stake bail matters, money laundering, to name a few. Mention also must be made that in July 2015, Sanjay Sir was appointed to prosecute impeachment motion against a High Court judge before Judicial Inquiry Committee, which reflects his eminence as a lawyer of merit, repute, and integrity. In 2022, in a rare case, Supreme Court monitored investigation on the 2G spectrum case. Sir was appointed as a special prosecutor, which was an easy choice, undoubtedly. Sir is also a connoisseur of fine arts, which is manifested in his collection of paintings from some of the finest artists in the world. Sir's poem has been published in a book by the Academy of Fine Arts and Literature. It is indeed a privilege for us at the Delhi University to have Sir in our midst to enlighten us on the BNSS. May I kindly request Dr. Pushkumar Sir to felicitate Senior Advocate Sanjay Jain Sir. Our resource person, Professor Dr. Bhageshwari Desmal Madam, is a professor of remarkable distinction at our very own Faculty of Law, University of Delhi. Madam's area of specialization are in the field of criminal laws and gender justice. Donning many feathers to her hat, Madam encompasses various roles as an academician, author, champion of feminism, is a columnist, and also an activist. To her credit, Madam has successfully completed research projects funded by noble institutions like the NCW, NHRC, and the ICSSR. Regular contributor to national newspapers like the Times of India. Madam has also served as a resource person to various training programs of administrative officers and judicial officers across the institutions in India. Bhageshwari Madam is a popular face on Doordarshan and Sansad TV on legal discussions, sharing her academic scholarship on addressing societal challenges with insightful and meaningful discussion on the subject matter. At present, Dr. Bhageshwari Madam is actively working with the Department of Legal Affairs, Ministry of Law and Justice, in the multiple efforts made towards spreading awareness and educating people on the new legislation. For an academically brilliant professor who have had the distinction of being the university topper during her LLB and LLM days, it doesn't come as a surprise that Madam has had the distinction of publishing the first free textbook on these new legislation. May I request Professor Anu to please come and felicitate our resource person, Professor Dr. Bhageshwari Madam. Owing to the paucity of time, in all humility and with a sincere apology, I will have to tell our resource persons that the time allotted is 20 minutes, which is very inadequate, but I think yes. But I think that will only open up more avenues for a further discussion beyond today. So may I request our resource person, Senior Advocate Sanjay Jain sir, to kindly take his time on the dais.
Honorable Dean Ma'am, honorable professors, they are very honorable for me personally because I am a product of Law Faculty, Law Center 1. The students who are here, ladies and gentlemen, I begin with the quote of Larry Niven, who said, "Half of wisdom is learning what to unlearn." So the advent of these three new laws has thrown many a challenge on all of us, the lawyers, the law enforcing agencies, the law professors, and the litigant. And the greatest amongst the challenges is that of unlearning. Because now I will be entering my 40th year in the profession, and for 39 years I have dealt with CRPC, IPC and Indian Evidence Act. So suddenly this trilogy of new enactments are going to be a little nightmarish. Be that as it may, I begin my address by summarizing my subject as new dimensions to Bharatiya Nagarik Suraksha Sanhita, that is BNSS. Elizabeth Fry, the pioneer of prison reform in UK, said, "Punishment is not for revenge, but to lessen crime and reform the criminal." Keeping in mind the above salutary objective of criminal justice delivery system, the Parliament has perhaps enacted Bharatiya Nagarik Suraksha Sanhita, completely overhauling the existing criminal procedure under the CRPC 73, so as to make it more justice and citizen-centric rather than punishment-centric. BNSS ensures that the entire criminal justice machinery, right from the investigation to the trial, is in line with the technological advancements, so as to ensure effective and speedy justice for all. Therefore, I take this opportunity to discuss some of the key features of BNSS, which in my view can go a long way to ensure a speedy, efficient and citizen-centric delivery of justice. So the key features would perhaps be in the minds of all of us, because whenever there is a new regime, first of all we look at the positivity. So amongst the positive aspects is the forensic investigation, which has been sort of, I would say, ignored in our country for a good number of years, despite the tools being available, partly because of the lack of infrastructure and partly because of the lack of will. But now that it is here, I am reading, because it's there on the screen, under bullet point 1. Under the old CRPC, there was no statutory provision regarding crime scene management or any uniform rules on collection of forensic evidence. The new code unleashes the new potentials in crime investigation by introducing mandatory requirement of conducting forensic investigation for offences punishable for 7 years or more. This mandate is captured in 176(3) of BNSS, which requires forensic experts to visit crime scenes to collect forensic evidence. Further, to ensure authenticity of the process, Section 176(3) requires the entire process to be videographed on mobile phone or any other electronic device. This, in my view, is a significant step towards ensuring proper collection of forensic evidence from crime scenes involving serious offences, which will help the investigating agencies by providing a precise and objective analysis of evidence at crime scenes Using several scientific methods and techniques such as DNA analysis, fingerprints analysis, autopsy, pathology, toxicology, and ballistics analysis. Many of you might have read the book Innocent Man by John Grisham. This book provides an interesting look at how forensic sciences can turn to be game changer. The story talks about the conviction of two men on rape and murder charges in late 80s in USA based on forced confessions and corrupted evidence. After 11 years of wrongful incarceration, new evidence in the form of DNA evidence was discovered which revealed the actual culprit. Thus, the role of forensic science in criminal investigation can no longer be ignored. It is also significant to note that by not defining what constitutes forensic evidence, Parliament ensures that BNSS remains dynamic so as to include new advancements in the field of forensic science. So, on this aspect, you would have noticed that the enactment is fairly pragmatic and dynamic, because when we tend to define too many things and we give sort of exhaustive definitions, then as the time grows and the history of a particular legal regime, those definitions becomes prohibitive or inhibitive. So therefore, leaving certain things for interpretation and for society to adapt and grow with is a better proposition. Now, the second aspect is the strict timeline for grant of sanction for prosecution of public servants, which was a very important aspect which this new BNSS has dealt with. The Honorable Supreme Court recently observed in Vijay Raj Mohan, by causing delay in considering the request for sanction, the sanctioning authority stultifies judicial scrutiny, thereby vitiating the process of determination of the allegations against the corrupt official. Delays in prosecuting the corrupt breeds a culture of impunity and leads to systematic resignation to the existence of corruption in public life. Such inaction is fraught with the risk of making future generations getting accustomed to corruption as a way of life. Viewed in this context, the duty to take an early decision inheres in the power vested in the appointing authority to grant or to not grant sanction. CRPC did not prescribe any such timeline which allowed the government to unreasonably delay prosecution of public servants. The BNSS mandates the government to take the decision within 120 days, and if no decision is taken within 120 days, the sanction shall be deemed to have been accorded. This can be found in the second proviso to section 2181. Then the third aspect is the bail to under trials, which is now taken care of. BNSS also takes a leap in the rights of under trial prisoners by making a special provision for the first time offenders who can be released on bail if he or she has undergone imprisonment for a period extending up to 1/3 of the maximum period of imprisonment. This has been brought in 479. Earlier it was there in 436A in CRPC, but the period to be undergone was 50%. So now that being reduced to 1/3 is a substantial relief to an under trial, which is a positive aspect of this amendment, a new law. Now, safeguards against arrest in case of certain persons is another very important feature. The safeguards against arrest were provided in section 41 and 41A of CRPC, has now been consolidated in section 35 of BNSS. We are all aware of the judgment of Arnesh Kumar on 41A, the discretion of the police officer, wherever the police officer, the Supreme Court said that wherever police officer is of the view that he doesn't need to arrest, then he needs to give a notice compulsorily. So that was a regime which has been followed for some time, but between the gaps which existed, that is the statutory provision and the Supreme Court judgment, this new enactment takes care of that. So notably, a new addition has been made in subsection 7 of section 35, which provides that no arrest shall be made in case of an offence punishable for less than 3 years if the person is infirm or above the age of 60 years without prior permission of the officer, not below the rank of Deputy Superintendent of Police. And then we go to the fifth aspect, which is not necessary to arrest the accused at the time of filing the charge sheet, especially if the accused had not been arrested during the investigation. So proviso to section 190 is another change introduced to protect the rights of accused and in line with the judgment of Satyendra Kumar Antil versus CBI, which is a recent judgment passed by Justice Sanjay Krishna Kaul, and this aspect has been sort of absorbed in this new enactment. And then it clarifies that it is not obligatory for the accused to be taken into custody, especially if the person is not arrested during the investigation. The police officer shall take security from the accused for their appearance before the judicial magistrate. Additionally, it ensures the judicial magistrate receiving such a report should not reject it on the grounds that the accused has not been taken into custody. Then rights of the victim and the complainant. Now this is one aspect which was being developed in this country only by judge-made law, because so far as the statutory provisions were concerned, the rights of victim and the complainant were ignored for the longest of time, but now that aspect has been taken care of. So two significant provisions introduced in BNSS to ensure the rights of victim, complainant are respected in criminal proceedings. That is 272, the magistrate to give 30 days time to the complainant to be present before discharging the accused, and proviso to 360, while considering an application for withdrawal from prosecution, victim must be heard by the court. So these two aspects are important, though provisions similar to these two provisions were there, but effectively it was a long drawn process, because first the magistrate, it was to the discretion of the magistrate whether to accept a closure, not to accept the closure, and also if suppose in a given case the complainant would not have come to know about it, then he might not have been in a position to file a protest petition. And we have to see these aspects also not only from the law as it is administered in the big cities or in the metros, but in these small towns where the same legal regime is being implemented, but not with so much of finesse or I would say accomplished manner of executing it. So this particular provision which secures the rights of the victims and the complainants is extremely important. Then electronic and digital ecosystem. BNS has introduced a comprehensive ecosystem which encourages use of electronic and digital technology for better administration of justice. Some of the key additions include recording of search and seizure through video and audio electronic means. Section 105 is to be seen in this aspect. However, I have just cautioned that the impact of section 63 BSA on section 105 would have to be analyzed. Dr. Deswal is sitting here, she may take note of it, because it requires the police to submit section 63 certificate every time any evidence is seized. So it will have some kind of a SOP will have to be placed into system, introduced into system to ensure that it doesn't take too much of time. Otherwise, all the reforms that you intend to do will go waste by virtue of all these procedural rigors which have been introduced. So on this, there is an expert SOP which has been published by Ministry of Home Affairs. I have gone through that also, as per this expert SOP, as regards 63(4) of the Bharatiya Sakshya Adhiniyam, which has substituted Indian Evidence Act, if one has to see, then this SOP says that the above expert should not be confused with the expert defined in section 39(2) of BSA, which states that when in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of the IT Act is a relevant fact. And then it has further been explained here. So the first responder, that is the SHO, can submit the record of audio-video documentation in any mirror copy along with the chain of custody of primary evidence giving proper certifications as mandated in BSA along with them. The expert in this case could be responsible officer of sufficient seniority who is either himself evidence of the whole process or can state to the best of his knowledge and belief that affirmation of the handler as to the continuity and authenticity of it. The burden of proof in case of contention will be on defense to mount a challenge and prove the violation of authenticity, and at that time court can seek opinion of the examiner of electronic evidence. This aspect is important because whenever we speak about any system in place which is dealing with the criminal justice dispensation delivery aspects for the citizens, we have to strike a balance. We cannot only be talking about the rights of the accused persons, we also have to see the rights of the victims and the complainants. So therefore, whenever we introduce any system which makes the investigation much more tedious but much more organized at the same time, but which requires a lot of additional evidences to be produced in the course of trial, we need to have either a proper SOP, because these SOPs have to be elevated to the level of some kind of a delegated legislation, because they have not come in the BNSS itself. So it leaves a lot of discretion to the officers concerned, to the people who are administering this system. And if the discretion moves towards indifference or ignorance or negligence, then it will not achieve the desired result. So that is one aspect which needs to be taken care of, and I am very glad that Dr. Deswal is here and she will most probably look into this aspect. Then we have other aspects of electronic digital ecosystem which I am skipping because we don't have much time, and then we can go to some causes of concern, which is at page 9 if somebody is monitoring it. Some causes of concern are the causes or are the points which as an ordinary citizen all of us may be little apprehensive of. So it is of course the responsibility of the system to rise, to come up to the occasion, for the courts as well as the lawmakers to ensure that these provisions are not misused and do not result in further injustice to the consumer of the justice. So the first is no bail to those under trial prisoners if such a person is facing investigation, inquiry or trial in more than one offense or in multiple cases. Now 479 of BNSS deals with it. So however, it may be noted that this has been tried to be balanced by enhancing the punishment for malicious prosecution under the Bharatiya Nyaya Sanhita 2023. Why I am laying emphasis on it is this, that it is very easy if somebody wants to target somebody, that you lodge many cases against that person so that he is denied of bail under this provision. So to strike the balance, it was imperative and it was very important that there should be some more stringent provision to deal with the persons who file false complaints. So if we enhance the regime of malicious prosecution, only then that objective can be achieved. So it is in that context that when I examined this Bharatiya Nyaya Sanhita and I found that there is, it has been taken care of, then I was relatively satisfied. Otherwise, I would have been a little more vocal about this particular provision. The second aspect is zero FIR, which is quite disquieting if it is not handled with proper amount of self-restraint. To those who may not know, zero FIR is an FIR which can be registered in any police station, notwithstanding the limitations of territorial jurisdiction. While the provision of zero FIR under section 173 of BNSS is commendable, what makes me concerned is the standard operation procedure issued by the government, that is MHA, which allows the police station without territorial jurisdiction to conduct primary investigation before transferring the FIR to police station having territorial jurisdiction. In the regime which existed till now, which did accept zero FIR, there was no authority or power given to the police officers to investigate that. Now, how big is the scope of primary investigation, how limited it is nowhere defined. So this is riddled with a great deal of speculative uncertainties. And if a police officer, I mean, if suppose somebody is a resident in Delhi and a FIR is registered in Nagaland, and in the name of primary investigation, the police officer comes from there and arrests somebody. So it is a little disquieting. The possibilities are little disquieting. I mean, the purpose is good, that all right, the complainant should not be deprived of his right to file the FIR. So the zero FIR concept is good, but the SOP, it is not the code which provides this provision. The SOP says that the police officer can do the primary investigation. So this aspect needs to be looked into by all the stakeholders, in my humble opinion. The next aspect is accused to be provided an opportunity to be heard before the magistrate takes cognizance. That is under section 223 of the BNSS. Now this aspect is, we all know that when do we go for private complaints? When we don't expect or we are not getting the proper justice from the police mechanism, then we go for private complaints. It is equivalent to that section 200 complaints earlier. Now, the earlier regime did not require the magistrate to first notify and bring the proposed accused before it, before taking cognizance. Now, in this new regime, what is to be ensured is that how do you ensure that the complainant who has approached the court will succeed in serving the proposed accused. Either the state takes the responsibility of serving the proposed accused. If the state doesn't take the responsibility of serving the proposed accused, then the complainant will be in a great difficulty because as we know that in our country serving the summons is as good as watching a horror movie. So it is something which needs to be looked into. Then informing the informant victim of progress of investigation, having appeared for Delhi police on number of matters, I find that this one provision at least may be put in abeyance, because you please think of a poor IO, investigating officer. Of course, I can understand that the complainant would be happy to know as to what is the progress in the case. But please see, the law as has been developed over the years as regards investigation by the police, even the courts don't interfere in that. And their investigation, unless it is complete, may have certain sensitive aspects. So, if the IO has to now become a letter writer, every 90 days he has to inform to the complainant as to what is the progress, and whatever is his perception of progress in the investigation may not be in alignment with the perception of the complainant. So he will approach either the commissioner of police or the senior police officers or the court, complaining against the IO that look, your progress report is not satisfactory, it is lacking in this aspect, it is lacking in that aspect. So it will make the life of investigating officer miserable, because when we are talking about something like BNSS, it has to be balanced towards all the stakeholders. I mean, you can't assume that an investigating officer is a villain or is not going to do his job properly. There is an inherent presumption in favor of the investigating officer unless there is a material to the contrary. So this requirement of his notifying the complainant, according to me, is little overbearing. Though it will have other arguments that all right, victim has a right to know, but then how much during the investigation? That is the question. Then handcuffing is the next aspect which almost everybody is extremely agitated about, because it is contrary to what Prem Shankar Shukla judgment of Supreme Court says. So the precautions which were recommended or suggested in Prem Shankar Shukla judgment appear to have not been taken note of in this provision, which permits handcuffing But to be fair to the lawmakers, they have recommended it only in respect of heinous crimes, but ultimately they have left it to the discretion of the police officers only. So again I am saying, where media is very vibrant, in those places handcuffing may be resorted to with discretion, but where there is no media, you think of small towns, villages, or places in the country which are not accessible to accessible by road, and the media might not reach. So what happens to the basic human right of that accused if he is handcuffed wrongly by the wrong use of discretion of the police officer? So that is one aspect. Another is the default bail. I'm within 20 minutes, or I have reached? All right. I'm just concluding it. So the default bail is the last aspect. The last provision that I wish to highlight is section 187, which lays down the provision for default bail. Although the total number of days for police custody remain 15 days, as was in CRPC, what is the cause of concern that the new provision allows up to 15 days of police custody, which can be authorized in parts during the initial 40 or 60 days out of detention period of 60 or 90 days respectively. Many legal scholars have expressed concern that this may lead to denial of bail for the entire period if the police have not exhausted the 15 days custody, which I believe is a genuine and needs to be pondered upon. Moreover, there is also no requirement to take the custody in first 15 days of remand, but can be taken any time during the initial 40 to 60 days. In fact, the report of the department related Parliament Committee also suggested that a suitable amendment may be brought to provide greater clarity in the interpretation of this particular provision of law. So in the end, I would like to say that we have what we have often heard, that rules of procedure are the handmaiden of justice and not the mistress of justice. So we believe that the stakeholders will use them with proper scrutiny and discretion and self-restraint and discipline. And we must not forget that the ultimate goal is justice, and rule of procedure are only means to achieve the same. So this is pretty much what I had to say. Now the questions are most welcomed. It is later on? All right. Okay. Oh, yes, I didn't know the procedure. Okay. Thank you. Thank you. Thank you.
Thank you so much, sir. Now, since we are waiting patiently for Madam Vageshwari also to deliver her session, may I call upon you, ma'am, to please come and take your time. After ma'am completes, then we can throw open the floor for questions. Please limit yourself to the questions, because we are running out of time. So in order to address the question lucidly, do frame your questions in your mind already. Thank
you. Respected Dean Ma'am, Professor Anju Tikku, my colleague Ratnabali, Dean Academics, respected Alka Chawla Ma'am, the Professor in charge of Campus Law Center, Professor in charge of Law Center 2, Dr. Anupam Jha, Dr. Pushp Kumar, the Professor in charge of 5-year law, my dear colleagues and students, it's a pleasure to be discussing with you today BNSS, which is the Bharatiya Nagarik Suraksha Sanhita of 2023. This is a momentous occasion. Today, as we have enacted the 3 laws, since midnight, the first FIR to be registered under these laws, it was registered at 12:15 p.m. today in Kamla Nagar. Okay. So the laws, we have kick-started with these laws now, and with Delhi itself. And today, as we implement these laws, I'm reminded of the popular song from a Hindi movie, Chodo Kal Ki Baatein, Kal Ki Baat Purani. Now it is the time to herald the 3 new laws, understand them in the light of the legislative intent, what our lawmakers intended the new laws to be, because it is evident from the title itself. IPC being replaced by Bharatiya Nyaya Sanhita. The shift is perceptible. We know it is from punishment towards justice, because in our criminal justice system, punishment to the accused does not necessarily translate into justice for the victim. The accused gets punishment, but what about the victim? And what about a person who's wrongly accused of a crime? And what about the society at large? Isn't it that under social contract we have bartered away our freedoms to the state, but in exchange what we expect is safety, security, our rights to be protected by the state. And it is only when state help is not available that we exercise the right of private defense. So now with BNS replacing IPC and then coming to the procedural law instead of CRPC of 1973, now what we have is Bharatiya Nagarik Suraksha Sanhita 2023. From the title itself, it is very clear that the law, it is meant for our people, for our citizens. So this is a law which has been enacted by our democratically elected leaders for our people. Unlike the old archaic and colonial laws which were enacted by our colonial rulers, by our imperial rulers for our subjects. And that is why, what was the title of the law? Penal law, penalty. Procedural law, merely objectively laying down the procedure. See, this is the prescribed code of conduct. If you don't fall in line, so we have prescribed an elaborate procedure and you would be punished according to that. Now, that was something which was not taking account of the safety and security that every state needs to guarantee to its people. But they did not need to do that. Why? Because they were not our own people. So they were not enacting a laws for their own people. They were not answerable to us. But those whom we have voted to power, now they are answerable to us. So they better make a law which protects our interests, and in case we don't like certain provisions or we have certain apprehensions regarding certain provisions, they would have to be put on hold, like we see section 106 subsection 2 of the BNS, the law dealing with death by negligence. Now there is this one single provision, subsection 2 of 106, which has been put on hold as of now, while the other 3 laws, they have come in force. And that is why, because that is a law, that is a provision which has now made it a legal obligation to inform the authorities. If I have committed an accident, if I run away from the scene, I can be punished with imprisonment up to 10 years. Now this appears very draconian. Then the truckers, they were protesting. Why? Because they drive not under very conducive conditions, long hours of driving, and then suppose there is an accident. They are supposed to inform the authorities, that is what the law say. But what they believed was that in case they stopped at that place, maybe their vehicles would be damaged, maybe they would be lynched by the public, and that is why they protested, because they were not aware that on the day when this BNS comes in force, on the same day we have BNSS also being implemented. And BNSS has certain very beautiful provisions regarding zero FIR, as Shri Sanjay Jain ji just elaborated upon. That is, of course, we have to take that too with a pinch of salt, because there are certain apprehensions regarding the utility of zero FIR also. But at the same time, what is being introduced side by side is EFIR. So now, irrespective of the jurisdiction, you can register an FIR. Irrespective of the fact that you cannot reach at a police station, you can just log into the website, you can just pick up your phone, dial a number, inform the police, because that is what the law mandates. The law doesn't say that you have to yourselves take the victim to the hospital. What it says is you are supposed to inform the authorities. And here, sir, since you were talking about zero FIR and why there is this preliminary investigation that is being talked about, the reason being, see, if we talk about 106 only, if you've informed the authorities, the objective was that medical help could be made available to one who was a victim of a hit and run accident, so as to minimize the casualties which can be done if medical help is made available during the crucial golden hour. Okay, so now the accused flees from the spot. Information reaches the police by means of an EFIR. They will not start action on that till the time, within a period of 3 days, the accused does not visit the police station in person and put his signatures on the EFIR. But at least when they've got an information that somebody is lying injured, so at least medical help can be made available to such a person. So that was the objective. See, because if you go by the NCRB data, the number of lives that are lost annually in hit and run accidents far outnumber the number of lives that are lost annually in murders. So that is some area which needed to be addressed. But then the only contentious thing about that provision was that it had made giving of information mandatory. And when we talk about the constitutional aspect, Article 20, how can you ask an accused to give information of a crime that has been committed by him? Would that not amount to a voluntary admission? So because of this constitutional aspect, this was a provision which has been put on hold, rightly so, because we have a right to express our opinion, and our lawmakers, they would listen to what our fears are, and then they would definitely address them. So when we talk about especially the provisions of BNSS, now can we run the PPT? I thought that I would be given only 20 minutes, so that is why I had not prepared a PPT, but since Ratna told me that, see, you can use a PPT, so this is one which I had used for some other presentation, but I'll be just picking up the provisions regarding BNSS from this one. So in BNSS, the changes that have been introduced are a total of 92 new sections, subsections and clauses have been introduced. The total number of modified provisions are 117. We've deleted 14 sections, and audio, video, electronic means are required at 35 places. Similarly, timelines have been specified now at 35 places. Next. Now, if we talk about the law, again, after such an extensive review of the provisions by a practitioner of the law, I would be more focusing on the academic perspective and why we needed this kind of a change, because we all know how we got our penal laws in the first place. The first Indian Law Commission, thereafter the second Law Commission, 1845, that is why we call our IPC the Maculay's Code. Now, Lex Loci report 1840, it was something which actually was very divisive in the sense, otherwise we would have got a uniform civil code way back. It was because of this report that they recommended that maybe we need to have secular laws, we need to have one uniform laws for all of the people in criminal matters, but personal matters, let them be divided. Let a Hindu be governed by a Hindu law, let a Muslim be governed by a Muslim law. We got IPC in 1860. And CRPC in 1873? No. Immediately the year that IPC was enacted in 1861, and then again in 1862 we got two procedural codes. One was applicable to the presidencies and one was applicable to the provinces. Then they were both consolidated in 1898, amended in 1973, but once we got our independence, we realized that now was the time to constitutionalize our procedure. We cannot just merely objectively apply the procedures, because we are applying these procedures to our people, so that cannot be done at the cost of compromising on their basic rights. And that is why, on the basis of 41st report of the 50th Law Commission, CRPC, we overhauled our CRPC in the year 1973. The same report had also recommended an overhaul of the IPC, but it was like too big a deal at that time. It appeared to be too much of a hassle, but procedural law was needed to be amended, and that is what we did. Indian Evidence Act, anyway, that was an old law. It was amended in the wake of Information Technology Act in the year 2000, then again in the year 2008, but that was to make it contemporary. Next, please. So the objective of anyway all the three laws is decolonization. So that is how what we have done. We have removed terms such as the Queen, British calendar, jury person, Privy Council. So all these terms now, they have been effaced from the statute. We've tried to make the laws contemporary by taking account of electronic records, digital records, and all these things. We've tried to use progressive language. See, earlier we did not have a definition of the term child. Now who's a child? A person below the age of 18 years. Earlier under the law we did not define the term child, and that is why even if we talked about a basic provision such as kidnapping, we had different age for boys and girls, because that is how the age of minority was looked at. But now there is a progressive language, so every child, irrespective of a male, female or a trans person, every person would be included. These are laws that have aligned with new legislative enactments. We already have the POCSO, we have the ITPA. These provisions under the new law, they are aligning with that, with the Information Technology Act. Then we have also tried to incorporate judicial pronouncements. We already had judgment in Lalita Kumari versus State of UP. Now, all those provisions regarding FIR, they have been included under section 173 of the BNSS, which replaces section 154 of the CRPC. Next, please, because we are dealing with this. So what is the objective behind overhaul of the law? To ensure fast and efficient justice delivery. Why? Because we all know justice delayed is justice denied. But then again, justice hurried is justice buried. So this is a very delicate balance that needs to be, that we need to strike. But then without compromising on the quality of the justice, and also at the same time ensuring that justice should not take too much of a time, that the justice no longer stays sweeter. So that is why, see, we've all seen that movie Damini, you remember? And that landmark dialogue which stays with us long after we've left the cinema hall also, and that is Tariq pe Tariq. And that is what our courts are synonymous with. So now when we have this BNSS, this has prescribed specified timelines. Investigation to be completed within a period of 2 months. Trial to be completed within a period of 2 months, some places 3 months. Thereafter, once the trial has been concluded, the judges, they cannot just keep sitting on the order. They need to pronounce it within a specified time period. So now there is a specified timeline for each of the processes that are given under our procedural law. Then releasing under trials on personal bond who have spent half of maximum prescribed sentence in custody. Since I see most of my colleagues from the law faculty here, we've all read Motiram judgment and the lines of Justice Krishna Iyer when he said that asking a mason to pay 10,000 rupees as surety, and then also to insist that no, I need someone who can stand guarantee for him from this very jurisdiction, whereas that person was a migrant laborer. And Justice Krishna Iyer, he beautifully remarked that, see, affluents do not befriend indigents. So where would this person get someone to stand surety for him? So in such cases, once a person has spent half of maximum prescribed sentence in custody, we can release under trials on their personal bond. Now that's such a lovely provision. Reducing complexity by streamlining legal procedures. We have to reduce pendency. We have prescribed timelines. The objective is to improve rate of conviction. See, for any progressive country, rate of conviction is extremely important. And that is a message which this law gives out loud and clear, that, see, innocents have nothing to fear and the guilty will not be spared. So that is something when you read these three laws in what we call as, when you read these all together, so you will understand that yes, these are laws which have provided foolproof mechanisms by making provisions for forensic. Forensics would be invoked here. We've got Dr. Seema Singh with us here, who would be elaborating more on the forensic aspects of the law. In addition to that, we are also talking about electronic evidence, we are talking about documentary evidence, and we are talking about timelines, and then the kind of powers that have been given to the police to conduct investigations coupled with the modern technology and all. I'm sure the rate of conviction will improve in the times to come. Then we have to leverage technology for trials. They can be conducted electronically. See, so many times, why do we get these tariqs in the courts? That is because aaj mera muwakkil bimar hai, aaj mera wakil nahi aa paya. So all these adjournments, why are these happening? Now we can hold all these proceedings electronically. A person can be examined. He might be sitting at his place, but the examination can be conducted electronically. Similarly, for proclaimed offenders, see, a person runs away from the country and we are left grappling with what to do in such cases. So once we've proclaimed him to be an offender, we will carry on with the trial. Now, why we would not carry on trials earlier? That was because the principles of natural justice would be violated. We do not go unless and until the other person is also present to defend his side. That is that audi alterum partem. But now, if the accused accused doesn't want to be present before the courts, let him not be present. He can do that at his own peril. We will carry on with the trial. We will examine all the witnesses also in absentia. We even have provisions for joint trials now in BSA. See, one of the offenders is not there, the others are there. One of the offender has been evading arrest. He would also be put up to trial along with his the other accused persons. So let the accused not be present. We will conduct a trial, we'll also award a punishment. The only problem would be regarding execution or administration of that punishment. For that, we would have to rely on these extradition treaties and all. Then utilization of forensics, now it has been mandated for offenses that are punishable with imprisonment of 7 years and more. Next. Just 2 more minutes. Next, please. So now there's a paradigm shift. There is a progressive approach. Instead of focusing now only on punishment, what is the focus now on? Providing justice to all stakeholders. That is, if you read the BNS and also the Bharatiya Nagarik Suraksha Sanhita, all the stakeholders, all the people of our country, that could be an accused, that could be a victim, and that could be also the general public at large. So we have introduced the concept of restorative justice. See, restorative justice has been prescribed as a punishment under the BNS, but it has been defined under BNSS. See, these provisions, you cannot amend one without amending the other two. These 3 provisions, they have to be read. These 3 laws, they are to be read together. So that is why when we talk about proceeds of organized crime, when we talk about property, simple definition of property, when we talk about this restorative justice, the definitions, they have been given under the BNSS. So restorative, this concept of restorative, not the definition of community service has been provided under the BNSS, which is a non-custodial kind of punishment in which no remuneration is to be paid to the accused. Now, why this was meant to be clarified, why expressly it has been spelled out under the law is because you must have seen that whenever an accused is awarded life imprisonment, those lifers, they stake a claim to minimum wages. That see, we've been working, so we need to be given some sort of a compensation for the work that we are putting in. Why? Because our constitution forbids begar. Okay. So little do they realize that, see, you are being made to do this rigorous imprisonment because you have committed a crime. So this is your punishment for that. And if you are being paid certain minimum wages, that is just a benevolence of the state. So now in order to rule out any sort of a controversy wherein even if we awarded a token punishment, a non-custodial sentence was awarded to an accused in which he was asked to do certain community service, he should not come to the court saying that, see, I need to be compensated for that. So the law has made it very clear, you would not be entitled to any remuneration for that. So now there's a better structuring in the laws, as we discussed in the previous section also, all the definitions, especially in BNS, which were spread earlier from section 6 to section 52. Now they've been all incorporated in one single provision, which is section 2. Okay, similarly in CRPC also, the BNSS, there is a better structuring. It has now been, made a people-friendly law because laws, they are meant for the people. Not only for the law academicians, judges or lawyers, they are meant for the people. So it should be in a language which makes it easy to comprehend for everyone. So next please. Okay. So in petty offenses, summary trials have been made mandatory. Accused may be examined through video conferencing. Yes, coming to victim. Just 2 more minutes, Mercy, before I wind up. Because, so see, when we talk about victims, now victims have to be supplied copies of FIRs. Earlier under the law, it talked only about informant who had to be given a copy of the FIR. Now they've also added the term victim. And now victims, they are also to be kept updated about the progress of investigation, and in cases where punishment is 7 years or more, the victim has to be heard before the state decides to withdraw prosecution. Witness protection scheme, that has also been introduced. So hitherto we did not have any specific provision for witness protection scheme, but now we have that in the statute itself. And then rights of accused person, the jurisprudence that we developed. See, although we had got a CRPC in 1973, so now people, they usually ask a question that why did we need this BNSS? Because that was not a colonial law. CRPC was our own law. But see, we got CRPC in 1973. 1978, how many of you remember the Bhagalpur blinding incident? 31 people, their eyes pierced with iron rods. hot burning H2SO4 poured into their eyes, and the state doesn't do a thing. In fact, there is an outrage when those police officers, they are to be prosecuted. The police department supports them. The local population of that area supports them. See, we cannot be lenient towards criminals. But no sorts of means that were employed can we justify those kind of means, even if the end was the same? That was to be meted out to those accused persons, even if they were hardened criminals. What about the rights of accused persons? Despite having tried to constitutionalize our CRPC, we had no provisions whatsoever for rights of accused persons or for rights even of convicts. See, their human rights don't evade them the moment they enter the prisons. They still have their rights. Then again, see, although the jurisprudence developed by way of decisions, then we had no presence of victims in our procedural law. Again, it was after the Mallimath Committee recommendations that we got this victim protection scheme or witness compensation fund and all these things. Concept of plea bargaining, it was not there in 1973. So as and when the need was required, we were amending the provisions, and what we had was a haphazard mix of provisions. It was a sort of khichdi. So what was required was a better structuring. Pure se we needed to overhaul it, and that is what has been done now, and that is why we have these new laws for us. Next, please. So we can just give all this a skip. I think the rest can be covered during the question and answer round. Thank you so much for a patient hearing.
I thank both our resource person for that brief summary of the BNSS. If there are any questions, please raise your questions. Are there questions to our resource persons? Or everything have been so clearly explained that there are no more questions? No questions? Okay. Yes, please.
Yes, ma'am. Ma'am, 173 clause 3 provides that for offences which has punishment from 3 to 7 years, the horizon of preliminary inquiry has been increased, as opposed to Lalita Kumari's judgment, which laid down only 5 conditions for preliminary inquiry. Now under 173 clause 3, the horizon is widened by including all of there are around 98 offences in BNSS which have punishment from 3 to 7 years. So don't you think this increasing the horizon of preliminary inquiry will increase the plight of the complainants, because there might be more chances of non-registration of FIRs?
See, what does the title of our new laws say? One is justice and other is Nagarik Suraksha. So Nagarik Suraksha, we are not protecting only our what we call as victims. What about those who are wrongly accused of crimes? See, 3 years is not a small amount. Even if a person is to be sentenced for 3 years of imprisonment, and sometimes what happens, these accusations, allegations, they are based on gospel truth. See, a preliminary inquiry is not going to do any sort of a harm. It is just in order to ascertain the veracity of the allegations leveled against a person, against the accused persons, and if the statements are right, of course, they will go ahead with the registration of the FIRs. Once the FIR has been registered, it has to be taken to its logical conclusion, which takes a lot of time and energy on part of the police, the prosecution, the judiciary, and the entire system. So what has to be seen is there actually some sort of a merit in the case or not? And that is it. In any way, even if we were talking about those 5 instances that were laid down in the Lalita Kumari's case, you see, this is just to segregate the grain from the chaff. And it doesn't have any sort of a negative implication. Thank you.
Thank you. With that, we wind up the second session on the Bharatiya Nagarik Suraksha Sanhita. On behalf of University of Delhi, I thank border resource persons. Thank you all.
Good afternoon to all of you. You all are aware, I think earlier already you have attended two sessions, one related with Bharatiya Nyaya Sanhita and the second one is Bharatiya Nagarik Suraksha Sanhita. And this is the third session where we are going to discuss Bharatiya Sakshya Adhiniyam 2023. So ideally Indian Evidence Act and Bharatiya Sakshya Adhiniyam, if you are going to translate Indian Evidence Act, then it seems that it is same. But actually there is some significant changes in Bharatiya Sakshya Adhiniyam. So as Vageshwari ma'am was discussing earlier, that the main purpose of this criminal law reform is basically to decolonize the things. And that's why this is also very much important that this is not the amendment in the previous legislation, but they all three are new legislations. So all the three previous legislations have already been repealed. So Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita, definitely one is substantive law, another one is procedural law, but they both are incomplete unless and until we are going to discuss the different provisions and the latest changes which has been incorporated in Bharatiya Sakshya Adhiniyam. So to discuss that what kind of new changes have been made in Bharatiya Sakshya Adhiniyam, I would like to invite Professor Rajni Abbi ma'am. And before requesting her to proceed with her speech, I would like to invite Anu ma'am to welcome Rajni Abbi ma'am. Now over to you, Rajni ma'am.
Respected Dean, Professor Anju Tikku, Professor Alka, Professor Ratnabali, and all my colleagues and students who are present here. First of all, you must be wondering, in the past two sessions, everybody stood up and spoke, and why are we sitting and speaking here? Let me give you a reason for it. Seema is not feeling very well, so she said, can I sit and speak? So it would be odd that if you go and speak, so that's why I'm sitting and speaking. There's no other reason for it, not of our seniority at least. We are here to speak about the Bharatiya Sakshya Adhiniyam. Let me tell you very frankly, till now, even we have not got used to speaking Bharatiya Sakshya Adhiniyam because from past 32 years that I have been teaching, we've been calling it Indian Evidence Act, and that comes very naturally to us. So it will take some time. And if we as law teachers are taking time, it will definitely take time for others also to adjust to the new system and get familiarized with it. As we all know that a very strong legal system is the backbone of any country, and when this legal system is jolted, or when we bring 3 new laws together and taking away such important laws which are the basis of the criminal jurisprudence, it is a very big step, and I think a very landmark date. As Vageshwari also said, that today is a very landmark date, and I hope you all know that such kind of programs are being held all over India, and I think there are around 15,000 police stations itself where these training programs are going on, and many other places where the Ministry of Home Affairs has directed that these programs should go on. Now, the Indian legal system, especially the criminal jurisprudence, if you see, from past many years, we've seen quite a number of changes which have happened in them, but they have not been incorporated as such in the Acts itself. So there was a need felt that there must be comprehensive legislations which should be brought out, whereby these changes, which have either been by some interpretation, some judicial pronouncements, or minor changes, they must all be consolidated now, and some new laws must be passed. During our conversation with some of the teachers, they were also saying, we could have also had very massive amendments also and not change it. But I think the ethos and the purpose of why we want to change these laws would not have been served if we would have just made these amendments. So the names itself, as everyone has said, it suggests that we wanted to bring foundational changes in these laws. Now, because there was this continuous need for these major reforms, these new laws have been passed. And because we are all law students or law teachers, we know that law is a very dynamic concept. And until it changes with the times, it is of no purpose. Major changes in some of the laws have been there since the Information Technology Act, etc. But they have been very few. So to consolidate all these new amendments have come. And therefore, as a reason of that, on 11th August 2023, the Bharatiya BS bill was presented, the Bharatiya Sakshya Adhiniyam was presented in the Lok Sabha to replace the Indian Evidence Act, and it was reviewed by the Standing Committee on Home Affairs. But during the reviewing, it was found that it was not sufficient, and therefore it was withdrawn. And then again, it was introduced on 12th December 2023, and the recommendations of the Standing Committee were all included in it, and as a result of which, many sections were amended, some of them were repealed also, due to the suggestions which were given by the Standing Committee. Now, it is very important to note that these suggestions of many stakeholders were taken, and opinion makers were taken before these amendments. And to name a few, all the governors, lieutenant governors, chief ministers, Chief Justice of India, Chief Justices of all the state high courts, bar councils, law universities and institutions, expert lawyers, civil societies, research centers, and academicians, they were invited and they were taken. It was a very long drawn process. We should not think that it has been done in a very hurried manner. So all these suggestions were taken. Let me tell you, we are all academicians sitting here. Some of them are advocates also. And during our teaching also, we felt that there was a need to change some of the provisions. Now, the Bharatiya Sakshya Adhiniyam was passed by the Lok Sabha on 20th December 2023, and on the next day itself, 21st December, the Rajya Sabha passed it, and 25th December, the President had given the assent to it. Now, although evidence is a procedural law, we all know, but it has certain substantive provisions also. And those are very important substantive provisions. And the most beautiful part of evidence law is that it applies both to civil as well as criminal law. Now, evidence, we all know, is a branch of law which is as important because all the facts which have been alleged have to be proved to the satisfaction of the court. हम लोग सब देखते हैं, मूवीज में देखते हैं, सब जगह देखते हैं, जहाँ भी जज बैठा है पीछे एक मूर्ति होती है जिसमें एक तराजू पकड़ा है पर आंखें बंद की होती हैं। अब बिना सबूत के किसी भी चीज को प्रूव नहीं किया जा सकता। सो इसलिए एविडेंस एक्ट बिकम्स so important for all civil liabilities to prove any civil obligation also and criminal laws also. जब तक आप जो भी फैक्ट बोल रहे हैं उसको प्रूव नहीं करेंगे तब तक उस पर कुछ लॉ अप्लाई नहीं हो सकता। And therefore, evidence we know has been a child of the Anglo-Saxon system. Shabnam is also sitting here, I think. We have all taught this for so many years. We earlier used to have a jury system. Evidence law को अगर समझना हो तो पहले हमारे पास jury system होता था. What was the purpose of the jury? We used to have 12 people from different areas of walks of life who they used to determine the facts. And they were not people of law, but they used to determine the facts, and when they used to determine the facts, they used to give it to the judge to apply the law. Now, once the jury system was gone, the judge had to perform both the functions. I hope all of you have seen those two movies, 12 Angry Men and Ek Ruka Hua Faisla, whereby we know the importance of the jury system and how it used to work. Now, the judge, when applies the laws of evidence, many important jurists have said at many places we do not require a law of evidence also, because whatever is logically relevant is relevant and that is evidence. But we definitely have to have certain rules of evidence whereby even if it is not logically relevant, sometimes it may be admissible. We all know the difference between relevancy, admissibility, and logical relevancy, etc. Now I'll talk about the major changes which have happened in the Bharatiya Sakshya Adhiniyam 2023. The first very important thing which happened in this act was, it was said that it is an act to consolidate and provide for general rules and principles of evidence for fair trial. This word fair trial I don't think has ever been used in the Evidence Act, the prior Evidence Act. So the purpose itself is clear, that what we want is a fair trial. So reference of fair trial was not there in the earlier act, and it emphasizes now on the fairness of trial by whatever means the evidence is given, whether it is oral, documentary, electronic. But the purpose of evidence is that the trial should be fair, and it should be fair not only, as everybody has said, not only to the victim but to the accused also. The system has to be fair, and therefore that is very important. The second important thing which happened in this act is now this act is applicable to court-martials also. Earlier they were restricted. The Evidence Act was not applicable to court-martials, but now it is applicable to court-martials also. The third important thing is that we used to have one section 4, which used to have defined presumptions. We used to have may presume, shall presume, conclusive proof, etc. Now they have all been merged into section 2. And as every other act, section 2 is the definition clause. These three definitions have also been shifted to section 2, and that is, although the definitions have not changed, but it is only that they have been shifted to section 2. One very important thing that has happened is, as we know that the name is Bharatiya Sakshya Adhiniyam. Now, because the whole purpose of it is to indigenize the laws, many terms which were used in the Indian Evidence Act have been removed. And terms like Parliament of UK, Provincial Acts, Crown Representatives, London Gazette, Jury, Dominion, Colony, Ireland, Commonwealth of Privy Council, Her Majesty's Dominion, all these words have been removed. Not only they have been removed because it's been a long time that India has been independent and we have our own legal system, but they have become archaic now. They are of no use of any purpose, and therefore they have lost their relevance in the new act. The next is that, as other speakers have also said, that the language of Bharatiya Sakshya Adhiniyam has been modernized also. Many words like, we used to have words like vakil, pleader, barrister, etc. They have also been removed, and now we have a single term like advocate, which is used, and now that is used in the Bharatiya Sakshya Adhiniyam. Now, the most important, I feel, one of the changes which has been made is the definition of document. Now, definition of document in section 2(1)(d), it has been expanded to include electronic digital records and email servers, logs, documents on computers, laptops, smartphones, messages, websites, clouds, voicemail messages stored in digital devices, etc. Now, this change acknowledges the shift from paper-based documentation to electronic form of communication, data storage. I hope we all remember in the first year we used to teach a case of contracts, Bhagwan Das Kedia case, in which the argument of the minority Justice Hidayatullah was that when the Contract Act was made, telephones were not invented, and therefore what kind of interpretation we should give. Now that kind of doubts have been removed, and all possible things, although I'm not saying that new things will not be invented after that. We are in an age where every day new things are, and I think that now it will cover the new developments which are happening by the artificial intelligence, the deep fakes which are being created. All those problems will be solved by these things. Initially, we used to also face a difficulty in examining a witness by video conferencing. We have a case we used to teach in Evidence Act, whereby we had to justify video conferencing is allowed, etc. But now it has been made part of the Act itself. Now, the next important thing which has happened is the definition of evidence has been expanded in section 2(1)(e). Now it includes information given electronically, appearances of witnesses, accused, experts, victims through electronic means, and therefore BSA now envisages a technically neutral approach, and which is very important. Then in section 22, coercion has been added. Earlier, if you remember, the confession used to be irrelevant if it was caused by inducement, threat, or promise. Now, even if it is caused by coercion, even then it would be irrelevant. In section 39, the scope of experts has also been expanded to include persons specially skilled in any other fields. As now, many new areas, new fields, new dimensions have been added, and now we have experts on electronics, etc. So experts would include experts in any other fields also. An explanation has also been added to section 24, whereby, this was pointed out by Professor Vageshwari also, where people are being tried jointly, and if one of the accused is absconding, or who has failed to comply with the proclamation under Bharatiya Sakshya Adhiniyam, is absent during the trial will still be conducted as a joint trial. This is a very important feature, that the trial will not stop even if somebody is absconding. The next important thing which has happened is to leverage the use of technology in collection of evidence. Significant changes have been introduced in the BSA that recognize contemporary technological processes, and a lot of explanations have been added to section 57 for that. For example, an electronic or digital record which is created or stored or simultaneously or sequentially in multiple files, then each file will be considered as an original. An electronic or digital record is produced from proper custody. It is sufficient to prove that they contain unless it is disputed. A video recording is simultaneously stored in electronic form and transmitted or broadcast to another. Each of these stored recordings is original. So many such kind of explanations have been added to section 57. Next is the scope of secondary evidence has been expanded in section 58. Secondary evidence, although some people would find it very funny, that oral admissions, written admissions, and evidence produced by a person who is skilled in examining certain documents or technical voluminous cannot be conveniently examined, and therefore they have been included in secondary evidence. Next is that section 138 has been also amended. Earlier, an accomplice was found competent to give a testimony, and even a conviction based on uncorroborated testimony of an accomplice was sufficient. But we all know that the courts, as a matter of rule, had established this, that corroboration in material particulars is required. But that was as a matter of rule, the courts had interpreted it. Although it was part of one of the illustrations in a section, section 114, illustration B, but the courts insisted on corroboration in material particulars. But now section 138 has been amended, and it says that an accomplice to testify in court against the person accused of a crime and conviction is not illegal when it is based on corroborated testimony. So they have removed that doubt once and for all, that it has to be a corroborated testimony, and help can, earlier help was taken from 114B, so that has been now removed. The last point which I would want to make is section 165. It says no court can require any communication between any ministers and President of India to be produced before it. And that is a very important thing. We used to have privileged communications earlier also, but any communication between a minister and the President of India, you cannot bring it in court of law. Now, these are some of the changes. Broadly, I have talked about some of the changes, although, let me tell you, I think Bharatiya Sakshi Adhiniyam is the one which has the least number of changes, and the most number of changes which have happened are because of the electronic form of records which are there. Otherwise, the whole concept of evidence has remained the same. But there are 2-3 concerns which have also been raised, and which I also feel that they should be addressed to. The first is problems with electronic records. The Supreme Court in 2014 itself had acknowledged that electronic records are prone to manipulation and alteration, and sufficient precautions must be taken if you are relying solely on electronic records. Now, seeing today's developments, we have seen the kind of tampering which can happen, all this problem of NEET examination which is going on. This is all tampering, this is all mishandling of electronic things which is happening. Some days back, I saw a documentary on Netflix, and that was on a post office scam which happened in UK. Some years back, there was a very big post office scam whereby the post offices, and at that time they were under the government, they employed a company, an independent company, to electronically manage all the post offices. A lot of people used to deposit a lot of money also in post offices in UK. Now, there was some tampering or something which happened wrong in that electronic system, and as a result of that, more than 200 postmasters were held to be criminals. They were even jailed. Some of them, out of shame, even committed suicide. It was such a big scam, and later on, there was an inquiry which was held, and it was held that it was because of that electronic scam only that it happened. Now imagine, you're holding electronic records and somebody tampers with it, and you're solely relying on it. So a lot of precaution has to be taken, especially in those cases where you are heavily relying on them. The second concern, which I always, when I've been teaching evidence from a long time, the definition of evidence, it includes documentary evidence and oral evidence. Although real evidence, we recognize it as evidence, but it is not part of the definition. because the weapon by which the crime has been committed, the clothes, the other things, they are also part of evidence, but they are not recognized in the definition of evidence. I think it was time that they could have included real evidence also in the definition of evidence. The next thing which I felt, this is only my personal kind of an opinion, we've been interpreting section 112 a lot. And section 112 is a presumption whereby a child is presumed to be legitimate if he is born within valid marriage, or within 280 days of the dissolution of marriage, of course, the woman remaining unmarried at that time. Now, over a period of time, because the only way to rebut that presumption is that you prove non-access. Now, over a period of time, the courts have started recognizing DNA testing, etc., for non-access also. So, somewhere in the Act, if a place would have been given to that also, I think it would have been in line and it would have rested this controversy regarding use of DNA, etc. So, probably in some other time they would include them in the amendments, but let me tell you that all these three acts which have been made functional from today will definitely improve the system. Of course, there are concerns. There are concerns regarding zero FIR as they were raised, that any police officer can now have a primary investigation also, and now not only investigation, probably they'll have the power to arrest a person also on the basis of zero FIR. So all these concerns are there, but of course, as we know, law is a developing thing, and definitely some SOPs will definitely come, and if some things are found that they are not working, they will definitely be taken with. Thank you so much.
Thank you so much, Rajni ma'am, and I think you have covered all the major changes which have been incorporated in Bharatiya Sakshi Adhiniyam, so there is very little less has been left for me to speak about Bharatiya Sakshi Adhiniyam, but one thing is very much important, as you pointed out, that Bharatiya Sakshi Adhiniyam is a legislation where we can see minimum number of changes. But the important issue is why it is like that. So there are certain things which I personally feel that they are very much important. I was not in the morning session, but I am very much sure that all the things, means the kind of changes has been taken place in Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita that has already been discussed. And we have seen that how in Bharatiya Nagrik Suraksha Sanhita, they have tried to speed up the entire process. Now the important question is, once they are going to talk about speeding up the process, how basically it is going to be implemented. And the second important question is, in Bharatiya Nyaya Sanhita, they have also included several new offences, like Rajdroh ko hata karke us jagah Rashtradoh laya gaya, terrorism ko laya gaya. So remember, we should not forget that these days the criminals are getting more and more smarter. So the important thing is how much our Bharatiya Sakshi Adhiniyam is able to deal with the smartness of the criminals. So that's why earlier, because I have very much remember, we all have seen the movie No One Killed Jessica. And I remember that police officer who has investigated this case, he told me that they were just patrolling and they heard noise of this gunshot. And when they reached at the place where the murder of Jessica Lal was committed, and they inquired with around 250 persons present in the party, कि किसी ने देखा कि जेसिका लाल को किसने मारा? Everybody said कि I haven't seen anything. Now the biggest challenge before the criminal justice system is, if you are a witness and you want to give a testimony, subsequently it becomes a problematic thing from the witness himself. So ज़्यादातर cases में what we have seen, the witnesses are going to turn hostile. And investigation is the most important part of the entire criminal justice system. So once the investigation has been vitiated, definitely the trial is not going to reach on the logical conclusion. That's why in Bharatiya Nagrik Suraksha Sanhita as well as in Bharatiya Sakshi Adhiniyam, they have put a lots of emphasis on forensic science and forensic experts. And as we have seen earlier in all those cases where the prescribed punishment is 7 years or above, it is mandatory that the crime scene must be visited by forensic experts. So what is the reason behind that? So if you are going to keep such kind of provisions in CRPC, similarly you are bound to make certain changes in Indian Evidence Act also. I am agree with what Rajni Abhi ma'am has said, that is still the clause which is dealing with the expert opinion, they have only added certain things like the experts in the digital and electronic experts. Now the important question is how much weightage should be given to a particular outcome of a particular scientific technology. Like very recently she just told that DNA profiling. So whether it is high time to change the interpretation of 112, but I personally believe that one important reason that why it has not been changed, as per me, perhaps they want to, means that particular section is just to give protection to the child. And that is the reason maybe they have not changed it. But the important thing is whether once we are going to talk about or divide the evidentiary value of different evidences on the basis of may presume, shall presume and conclusive proof, whether it is high time to classify these different kind of scientific technologies in may presume, shall presume and conclusive proof also. Because we have seen the problem which is faced by, particularly by the police personnel, once they are going to produce any evidence before the magisterial court, it is up to the discretion of the magistrate that whether they are going to accept those forensic evidences or not. So this is something which is very much important. And in Bharatiya Sakshi Adhiniyam, obviously there are some changes. Most of the things has already been discussed by Rajni Abhi ma'am, and I will also, because I have to speak, so definitely I am going to say something. In Indian Evidence Act was divided into 3 parts, but Bharatiya Sakshi Adhiniyam is divided into 4 parts. एक बात जो लगातार आती है, जो वही रजनी मैम ने भी उठाई, कि definitely under section 2 where they are going to discuss the definition of evidence, they have included documentary evidence, and in the entire Bharatiya Sakshi Adhiniyam, continuously if one term has been strongly used, that is the electronic and digital evidences. So either it is a digital signature, any other kind of electronic and digital evidences, definitely they are going to prove a very, very crucial role in deciding a particular matter. It can be a CCTV footage, it can be your mobile camera, it can be somebody's Facebook account, it can be somebody's mail, it can be your pen drive, it can be any other form of digital document. And now the important thing is they have also broadened the definition of primary evidences, which are definitely more authentic in comparison to the secondary evidences. So once you are going to forward one video or one clip or any other document from one mobile to another mobile, then each of the mobile should also be considered as a primary evidence. So they have put a lots of emphasis on the digital and electronic evidences as well as on the relevance of primary evidences. Certain things are also very much important, and one very important thing is for the first time they have added a schedule which was definitely not earlier in the original Indian Evidence Act, and you can see only one schedule in Indian Evidence Act where they are talking about 2 things. The first thing is I think it is basically to stop any kind of tampering with the digital and electronic evidences, and that is basically creating a kind of hash value. I think very less number of us are aware about this thing, but this is a very, very important change which has been made by the government by the parliament under the Bharatiya Sakshi Adhiniyam. So once you go on the schedule and you check it, they have mentioned 2 types of certificates. Certificate A and Certificate B. So remember, once you are going to produce any digital or electronic evidence to the police, or the police is going to collect any digital or electronic evidence, immediately they will create a hash value. Hash value is a kind of digital coding or something like that, and that hash value, it should be matched with the value which has been created by the expert. So part B of this schedule, it talks about the form which should be filled by the expert. So remember, one hash value will be created by the police and another hash value will be created by the expert. And there should be some match. If there is a mismatch, then the probability that there is definitely some tampering with the digital and electronic evidences. So I think this is something which is very important amendment which has been made in this Indian Evidence Act, because we have seen you are submitting one CD and there some other kind of document is going to be produced before the forensic experts, and there is some kind of mismatch between both the things. So I think it is definitely going to raise the standard or the value of the electronic evidences which can easily be produced by any of us. अभी हम लोग देखते हैं कि हर जगह CCTV कैमरा लगा हुआ है, सबके हाथ में मोबाइल है, तो ये सारी चीज़ें जितनी भी जिस तरीके के भी एविडेंसेस को प्रोड्यूस करना चाहते हो, and that's why I have seen that there are several cases are going to be sorted out on the basis of your mobile phones also. दूसरा इसमें एक इम्पॉर्टेंट जो डिजिटल पर हम लगातार बात कर रहे हैं, वागेश्वरी मैम एंड आई थिंक Sanjay sir had also talked about that, the registration of EFIR. That is also very important, because earlier what used to be happen, you are going to the police, they are not going to register your case, you don't have any proof. Now you register your FIR online, and that will be accepted. One more change which has been made in the part of confession, and this is very important because they have clubbed certain provisions which were earlier prescribed in the Indian Evidence Act, and basically I am talking about 24, 25, 26, 27, 28. So they have clubbed certain provisions and they have created only one provision, which is basically including earlier, means prior, which was prescribed under section 24, 25 and 27. Now that has been clubbed into one section only. So this is a new kind of thing, and as you are aware that in the Bharatiya Nyaya Sanhita they have made a change. And what is the change? If somebody is sitting outside India and abetting any kind of offense in India, abetting others to commit any offense in India, then in that circumstances there is a corresponding change in Indian Evidence Act also, which talks about the joint trial. So if the person is not, he is not in the India, then too he can be jointly tried. So these are certain important changes which have been made and which have been discussed in the Indian Evidence Act. But again I am repeating, they have put a lots of emphasis upon the digital and electronic evidences, and I think it is a very, very important point. And in the future, the rate of conviction, definitely it is going to rise, because now we are not relying too much upon the direct evidences, too much upon the testimony of an eyewitness, but the forensic evidences, the digital and electronic evidences, they are going to play a very important role. I think you have remembered the case of Kasab, when the entire incident has happened, that was recorded by different CCTV cameras. But then too it has taken many years to decide the matter. Now according to this Bharatiya Sakshi Adhiniyam, these digital devices, they can play a very important role as an evidence in deciding a particular matter. So I think we both have completed entire changes or amendments which have been made in the new Bharatiya Sakshi Adhiniyam, which have been included in the new Bharatiya Sakshi Adhiniyam, and I think we are very close to the time. So with this, yes, I am going to open the floor for the question answer session. So if any of you want to ask any question, you can please ask. And I think if you want to give any suggestion, that we also welcome.
Along with that of an expert. Now when we speak about expert, my question to you is that also for clarity, it's not that question in that sense, because I am little concerned about it, but at the same time I am not very clear about it by reading the act. These experts, whether these experts would include the private, the experts associated with private agencies also, or like self-employed professional experts, or they will have to be associated with some government agencies? Because that is the key question, because as of today, there are only 11 government agencies in the country, and by the time the certificate will come, it will take a year and it will delay the trial inevitably. So on this aspect, can you enlighten us?
Sir, I think they are, it is only the government agencies, because still the private laboratories are not allowed. And one bill was pending before the parliament regarding this, where they were planning to allow private laboratories and their report that should be admissible in the court, but that has not been passed yet. So till now, I think it is only the government agencies, it is not the private agencies. So it is also a big challenge, because you are going to say that within a particular time period, the investigation should be completed, the trial should be completed, but the important issue is how to develop that kind of infrastructure. So the number of forensic experts and forensic laboratories, that is also a...
Professor Deswal is also here, and all the top academicians of DU are here. My great concern is that all those time limits which we are talking about, and the expectation from police department to present the charge sheet in time to avoid the serious offenders getting default bail, etc. Now those situations will be compromised if this certificate from expert is made sort of an integral requirement for filing a charge sheet. So there has to be some clarity on this aspect. Will Rajni ma'am clarify on this?
I think over a period of time, the government will also realize, and they will start giving certificates to some private bodies also. Because otherwise, as you said, definitely it is going to derail the procedures also. And the purpose of giving timelines will all be defeated. But I think these SOPs and new things will definitely follow. Yes, Professor Vageshwari. So it will definitely be done. It has to be.
It will take some time,
It will take some time, but definitely
by the
it
time, because government has, I think they have allotted a good amount of money to implement all these things also. And this forensic mobile van, they have also mentioned that there should be forensic mobile vans. So wherever any crime has been committed, where the prescribed punishment is 7 or more than 7 years, that crime scenes should firstly be visited by this forensic experts. Because I remember the case of Arushi Talwar, उसमें यूपी पुलिस ने सबसे पहले जाके कमरा धुलवाया था, तो they themselves have destroyed all the relevant evidences. So I think these changes are, but implementing these amendments is also a big challenge, because it requires a huge investment in infrastructure. So how much time it is going to take, but at least it's a new beginning. So let's hope for the best. Any other question?
Good evening, ma'am. Ma'am, in IPC we had section 377, which talks about unnatural sexual offences. And basically it had two parts, that one is constitutional and other was unconstitutional part, which was struck down by Navjot Singh Johar judgment. So ma'am, basically I want to know कि BNS में इस section को remove क्यों कर दिया गया completely? And one more question, which is related to CRPC. Like in new BNSS, अगर आप CRPC में देखें तो हैंडकफ को लेके बहुत स्ट्रिक्ट प्रोविजंस थे, बट BNSS में उसको थोड़ा पुलिस की तरफ फेवर में कर दिया गया है कि पुलिस चाहे तो हैंडकफिंग बहुत इजीली कर सकती है. तो इस पे आप क्या बोलेंगे?
दूसरे का मैं दे देती हूँ, पहले का जवाब भागेश्वरी मैम देगी. जहाँ तक हैंडकफिंग का इशू है, यू आर अवेयर दैट देयर वाज अ जजमेंट ऑफ द सुप्रीम कोर्ट, जिसके बाद ये बोला गया कि हैंडकफिंग शुड नॉट बी अलाउड. So what was the problem? Suppose there is a criminal, there are 5 to 6 or 7 police personnel just to ensure it कि वो भाग ना जाए. एक तो ये एक बड़ा प्रॉब्लम था. तो मेजॉरिटी ऑफ द पुलिस पर्सनल्स दे आर गोइंग टू बी यूटिलाइज फॉर सच काइंड ऑफ पर्पजेस, जहाँ पे द लॉ एंड ऑर्डर सिचुएशन इज इम्प्लीमेंटिंग लॉ एंड ऑर्डर सिचुएशन इज अ बिगर चैलेंज. तो यहाँ पे जो इन्होंने किया है, यहाँ पे इन्होंने ये नहीं किया कि इन एवरी केस हैंड कफिंग इज रिक्वायर्ड, ओनली इन दोज केसेस वेयर द नेचर ऑफ द क्राइम इज हीनियस, जहाँ पे लग रहा है कि वो भाग जाएगा. ओनली एट दोज प्लेसेस दिस हैज बीन प्रिस्क्राइब्ड दैट हैंड कफिंग इट शुड बी allowed. और जहाँ तक 377 का है तो 377 में obviously there was two part, consensual and non-consensual. So consensual was decriminalized by the Supreme Court, not the non-consensual. But in the new Bharatiya Nyaya Sanhita, there is no provision dealing with homosexuality. But I think Vageshwari ma'am, if you want to add something, you can add.
377 is actually very contentious in the sense that non-consensual homosexuality, it was taken out, it was left as criminal, whereas consensual homosexuality was taken out of the ambit of crime. That was done in Navtej Singh Johar. Now what happened, that see, this is, we already have provisions when we talk about grievous hurt, when we talk about using criminal force, and I'm sure that not many people know that under IPC, sexual harassment of men is a crime too. See, when we talk about the POSH law, that protects only women because that is gender specific. But sexual harassment under the IPC, it was partially gender neutral in the sense that the perpetrator can only be a man, whereas the victim can be both a man as well as a woman. So since 2013, we have acknowledged that men can be subjected to sexual harassment. Now your concerns regarding penetrative sexual assault against men and where that is non-consensual. So for that we have provisions depending upon the gravity or the intensity of the crime. We can invoke simple hurt, grievous hurt, criminal force assault, and that is when it is to be read along with sexual harassment that can take care of that. Then another aspect of this is which is regarding to bestiality. Now that is a significant omission that I also feel because as of now, we don't have any provisions that would cover sexual assault against animals. That is, we already have a Prevention of Cruelty Against Animals Act, but the punishments that have been prescribed therein are hardly deterrent, going by any measure. So maybe we'll have to also amend that law. See, now this law has come into operation from today. There are so many corresponding enactments in which we would also have to bring about amendments, and Prevention of Cruelty Against Animals Act is one of them. That is it. Thank you.
Thank you so much. Thank you so much, Rajni ma'am.
Good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. We'll be starting the valedictory session in another 10 minutes as soon as the chief guest arrives. Thank you.
सर क्या नाम है पूछो तो नहीं क्या नाम है सर नाम क्या नहीं ये नहीं है यहाँ तीनों का है मैडम से साहब से बात करो हेलो नाम क्या था ठीक है ना सही है नाम तो बोलो ये तो है यार लाओ लाओ मेरे सर हेलो सर लगा
स्विच ऑफ करने के बाद इसको स्विच ऑन मोबाइल Ladies and gentlemen, a humble request to kindly settle down quickly. Our guests will arrive shortly. A humble request to everyone to kindly put their communication devices on either silent or switched off mode. Thank you very much. I request everyone to kindly settle down quickly. Thank you. I request everybody to kindly settle down. Thank you. Kindly be seated, and a gentle reminder again to kindly keep all mobile phones on either silent or switched off mode. Thank you. Good afternoon, ladies and gentlemen. On behalf of University of Delhi, a very warm welcome to our chief guest, Honorable Mr. Justice Vikas Mahajan, Judge, Delhi High Court. Respected Professor Yogesh Singh, Honorable Vice Chancellor, University of Delhi. Dr. Vikas Gupta, Registrar, University of Delhi. Professor Anju Tikku, Dean, Faculty of Law, University of Delhi. Professor Rajni Abbi, Proctor, University of Delhi. Professor K. Ratnabali, Dean, Academic Affairs, University of Delhi. I request everyone to kindly rise for the University Kulgeet.
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
श्रेष्ठ सुंदर दिव्य दिल्ली विश्वविद्यालय विहंगम
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम सकल वसुधा निज कुटुंब की भावना संस्कृति सनातन आधुनिक शिक्षा पुरातन ज्ञान धाराओं का संगम
देश की स्वाधीनता हित भूमिका शतकोटि वंदन
निष्ठा धृति सत्यम के मंगल दिव्य भावों का समागम
जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम
भव्य महाविद्यालयों के परिसरों से चिर सुशोभित श्रेष्ठ गुरुजन कर रहे नित्य छात्र और छात्राएं दीक्षित
सदचरित्राचार पावन साधना संकल्प संयम
नवल वैश्विक चेतना नव क्रांति संस्कारों का उद्गम जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
श्रेष्ठ सुंदर दिव्य दिल्ली विश्वविद्यालय विहंगम
जयति जय जय जयति जय जय ज्ञान का लोक अनुपम
ज्ञान का आलोक अनुपम
ज्ञान का लोक अनुपम
ज्ञान का आलोक अनुपम
Thank you. We welcome Professor Balram Pani, Dean of Colleges, University of Delhi. Light and brightness have been equated with positivity, and motivation is seen as harbinger of good. To start us off on an auspicious note, we will now have the lighting of the lamp. I request the dignitaries on the dais to kindly join us for lighting of the lamp. Thank you. Ladies and gentlemen, it is rightly said, change is the only constant in life, as has been elucidated in the various sessions held earlier today by august legal luminaries. They enlightened us about the new criminal laws, Bharatiya Nagarik Suraksha Sanhita, Bharatiya Nyaya Sanhita, and the Bharatiya Sakshay Adhiniyam. These laws are replacing the laws framed by the British that were meant to govern the Indians. The present laws, which are being framed by the present government, have been made with the intention of serving the nation and to give justice to the people of India. पुराने कानून देश पर शासन करने के लिए थे और नए कानून देश में न्याय देने, सेवा करने और उचित प्रबंधन के लिए बनाए जा रहे हैं. I request Dr. Vikas Gupta, Registrar, University of Delhi, to kindly deliver the welcome address.
Thank you so much. Most respected Honorable Vice Chancellor, Professor Yogesh Singh Sir, Chief Guest of today's program, Honorable Mr. Justice Vikas Mahajan, Judge, Delhi High Court, Professor Balram Pani, Dean of Colleges, Professor Anju Ali Tikku, Dean Faculty of Law, Professor Rajni Abi, Proctor, Professor K. Ratnabali, Dean Academic Affairs, esteemed guests, dignitaries, participants, and my dear students. Namaskar. It is an honor to welcome you all on this historic day when new criminal laws of India are being implemented. Today, as we gather here, our nation is witnessing significant transformations in its legal landscape aimed at enhancing justice, equity, and public safety. It gives me immense pleasure to welcome Honorable Justice Shri Vikas Mahajanji, Judge, High Court of Delhi, who has an illustrious career practicing at the top courts of the country, including representing the state of Himachal Pradesh as the Additional Advocate General in the Supreme Court of India. Sir, we welcome you. I would also like to welcome visionary Vice Chancellor, Professor Yogesh Singh Sir, who embodies the very definition of leadership in its truest sense. For Sir, I would like to express the feelings or thoughts of the entire university community through few lines. शिक्षा के क्षेत्र में किए आपने अद्वितीय काम, वसुधा में गूंज रहा है विश्वविद्यालय का नाम, संकल्प से आपके मिलती है प्रगति की नई राह, कोने कोने में फैल रही है ज्ञान की स्वर्णिम चाह, विश्वविद्यालय की नींव को और सुदृढ़ बनाया, विद्यता से हर युवा को देश प्रेम का पाठ पढ़ाया, राष्ट्र प्रेम प्रथम, शिक्षा सर्वम और मृदुल व्यवहार, हर योग आपका रहे सदैव विकास का सूत्रधार. It is a matter of pride for us that the colonial Indian Penal Code 1860 has been replaced by Bharatiya Nyaya Sanhita 2023, introducing praiseworthy elements like community service as a penalty for crimes, new section like offenses against the state, death penalty for gang rape of minors and mob lynching, etc. Also, Bharatiya Nagarik Suraksha Sanhita 2023 replaces the Code of Criminal Procedure 1973, which will ensure time-bound investigation, trial, and judgment within 30 days of the completion of arguments, mandatory video recording of the statement of sexual assault victims, amongst other progressive provisions. Another testament to our colonial burden, the Indian Evidence Act 1872 has been replaced by Bharatiya Sakshay Adhiniyam 2023, which focuses on digitization of all records, including case diary, FIR, charge sheet, and judgments. It makes digital records as evidence admissible in courts. As a result, from today onwards, digital records shall have the same legal effect, validity, and enforceability as paper records. The recent amendments and enactments in criminal laws have far-reaching implications for legal practitioners, law enforcement agencies, and the society at large. I am sure this session provided a platform, this seminar provided a platform for you to engage in insightful discussions, share expertise, and gain valuable perspectives on these developments. I have no doubt that during the course of today's seminar, you must have delved into the nuances of the new criminal laws, exploring their possible impact on various aspects of our criminal justice system. Our distinguished speakers and panelists shared their expertise, and participants had opportunities for interaction during the session. I am sure we will be further enriched by the much-awaited address of our chief guest, Justice Amit Mahajanji, on this very important step in the history of Bharat. Let us work together to enrich our understanding of these significant legal developments and contribute to shaping a safer, more just society for all. Thank you. Namaskar.
Thank you, sir. I request Professor Yogesh Singh, Honorable Vice Chancellor, University of Delhi, to kindly felicitate our chief guest, Honorable Mr. Justice Vikas Mahajan, Judge, Delhi High Court. Thank you, sir. I request Professor Anju Bali Tikku, Dean, Faculty of Law, to kindly give the introductory remarks.
Dhanyavad Mridula ji for inviting me on the dais to give the introductory remarks. सबसे पहले कुछ कर्टसी चीज़ें, कुछ मान्यताएं, कुछ मर्यादाएं जो निभानी है, जिम्मेवारी भी है, विशेषाधिकार भी है, और ये मैं मौका छोड़ना नहीं चाहूँगी, खासकर जस्टिस विकास महाजन के लिए. I've got no words to express my, I've got no words in fact. I'm at a loss of words to express my gratitude on behalf of the Faculty of Law that at a very short notice you readily agreed. And despite the fact that you had your own commitments, the very first day of opening of the courts, you accepted our invitation. I am really beholden to you, and we look forward to your continuous support and collaboration, and we would keep on bothering you, sir, time and again. And I believe I have got that much of space now from you that I can reach out to you and you would accommodate us. I'm sure at this moment I commit myself that I'll take care that in future we do not reach out to you at such short notice. Thank you very much on that count, sir, and we are really, we really appreciate and are really happy to have you amongst us. और जब आपने भगत सिंह जी का वो देखना चाहा तो दिल गदगद हो गया कि आपको जब हमने बुलाया और जो कुछ आपने थोड़े से समय में विचार रखे अपने, लगा कि नहीं अपने ही और अपनों को ही बुलाया, तो बहुत अच्छा किया. धन्यवाद, धन्यवाद. और उसी के साथ मैं इससे पहले कि अपने वाइस चांसलर साहब के बारे में कहूँ, मुझे लगा विकास स्क्वायर, सॉरी आई एम यूजिंग दैट वर्ड, हमारे पास विकास महाजन सर हैं एज chief guest, and we do have our registrar also by the same name, Vikas Gupta ji, and incidentally both of them when translated turns out to be development, and we are looking forward to development and enhancement of our educational space through our honorable vice chancellor, जो कि करता धरता हैं. परिवार के मुखिया के बारे में जितना भी कहा जाए वो कम होता है, and realizing that this whole family is huge family, I don't think I can convey the kind of time, energy, effort, focus, vision that he happens to reflect. And when he asks you, calls you up on a Sunday also talking about something academic, so it means that there is somebody who is talking sense and is very focused and needs and means whatever he is doing that. आपको हमारी ओर से बहुत बहुत धन्यवाद और साधुवाद, आप इतना समय दे रहे हैं. और उसी के साथ कहीं ना कहीं एक हमारे लिए भी एक इंस्पिरेशन होता है that despite multitasking, जब कभी बात हुई मैंने कहा multitasking, he said yes, अच्छा है. Despite multitasking, he still knows how to demarcate his time and gives you the direction that yes, we can do it and we will do it. Thank you very much for always being open and even at the cost of repetition. आपकी वो जो चेहरे पे मुस्कुराहट है वो जब बनी रहती है और आप बात करते हैं तो बस आधी चीज़ें तो उसी से निभ जाती हैं. आपकी मुस्कुराहट बनी रहे उसके लिए बहुत बहुत शुभकामनाएं और शुभेच्छाएं. Now coming to the focus of this program, we all understand that today the 3 new laws have been implemented, and with this there is a new era beginning, hopefully, wherein we would be moving away from retribution and deterrence over to somewhere integration instead of disintegration. Sir, if I might inform you, we had 3 sessions on the 3 criminal laws, and we happened to invite for IPC/BNS, which is now Bharatiya Nyaya Sanhita, we invited our own alumnus, Mr. Mohit Mathur, who is now the senior advocate, a proud alumnus. We feel very proud. And we also had for the second session, Bharatiya Nagrik Suraksha Samhita, again our own alumnus, Advocate Sanjay Jain, who is still amongst us, who happens to be the former Additional Solicitor General. So we have people from amongst us who have made a mark and are around so that they are experts in their respective areas, and specifically with reference to criminal law, because that is what we are talking about today. We had those 2 sessions, and with reference to the 3rd session, Indian Evidence Act and Bharatiya Sakshi Adhiniyam, we were expecting Dr. B. Ramaswamy, but because of some contingency he couldn't join us, and we had from our own colleagues, Professor Rajni Abhi and Dr. Seema Singh, who had this panel discussion on what are the changes. Now just briefly talking about the need of having these 3 laws, and not getting into the details because we look forward to hearing Justice Vikas Mahajan. The 3 sessions were focusing on that the changes that have been brought about, and those changes, how they would ultimately be implemented and what kind of implications would entail. We all understand that there are many discussions and narratives in social circles and legal circles, primarily because we see here majority of us belong to legal field. As far as the nomenclature of Bharatiya Nyaya Sanhita is concerned, there have been many debates, and specifically 2 segments that merely changing the nomenclature would not bring about a change in the attitude and approach of our entire criminal justice dispensation. But we realize over a period of time that when we happen to speak to experts, we do all understand that there is a beginning made in the right direction, and it is only time that would inform us as to whether we have been rightly able to implement the vision and the promise which has been laid down through Bharatiya Nyaya Sanhita, that we are not going to talk about, we are not going to focus on that penalty and labeling attitude. Instead, we need to think on the lines of reintegration, and that yes, to err is human, to forgive divine. Of course, as human beings, we cannot be divine, but certainly we can find out a process and mechanism wherein people who happen to get into those wrongful situations can be reintegrated and a restoration of the society is possible. Similarly, with reference to Criminal Procedure Code, we understand that there is a lot of resentment among the people about bail procedures, also about the detention and police custody, also about that with reference to scene of crime, there are many evidences which are lost. So during these 3 sessions, we tried to figure out what are the important components that have been brought about. But at the same time, realizing that any law cannot be perfect, any situation cannot be perfect, that's how we have left it open, that now there is a time to enter into a dialogue and rope in different layers and different segments of our professional strata, wherein we understand that the laws having been incorporated, how they are being implemented and where is the possibility of bringing about reforms. That's where the title says, Implementation of New Criminal Laws, the Way Forward. So we are at a juncture wherein we are looking forward to something which would be very nice and wonderful, so that we do have our aspirations as to whether through these laws which have been incorporated, we have the laws on the statute book and the textbook, how do we go from here? Because mainly it is interpretation, that's where your perspective, sir, would be really important. At that note, I leave the floor, expecting Justice Mahajan also and our Vice Chancellor sir, जो हालांकि लॉ से तो नहीं है, लेकिन बहुत कुछ ऐसा बयां कर जाते हैं कि कई बार हम लोगों को भी लगता है कि नहीं, ये भी एक नज़रिया था जो हमने शायद एज लॉ पीपल नहीं कंसिडर किया. एंड व्हेन वी से लॉ is relevant only for the society, so we need to hear different voices from different fields to understand what is the right approach. Thank you very much, sir, for sparing your time, and I really thank Professor Balram Pani also for having joined us and graced the occasion. Thank you very much.
Thank you very much, ma'am. I now request Professor Yogesh Singh, Honorable Vice Chancellor, University of Delhi, to kindly address us.
Good afternoon, Namaskar. Honorable Justice Vikram Mahajan ji, Judge, Delhi High Court, Professor Balram Pani, Dean of Colleges, University of Delhi, Dr. Vikas Gupta, Registrar, Professor Anju Tikku, Dean, Faculty of Law, Professor Rajni Abhi, Proctor, Professor Ratnabali, former ESG, Mr. Sanjay Jain ji, Finance Officer of University of Delhi, Shri Girish Ranjan ji, other respected faculty members, and my dear students, officers and officials of University of Delhi. Good afternoon to all of you. This is a very, very important topic because it has become reality today. 3 laws, now they are reality, they have implemented and forced in our country. And Dean, Faculty of Law has rightly said, the third perspective, although I don't have any perspective on the issue because it is very, very difficult to talk about law. Sometimes we may become unlawful also when we are talking about law. But you know, as a Vice Chancellor of University of Delhi, first of all, I would like to congratulate all of you that in QS World University ranking, Delhi University has been placed in 320th position, which is it's a matter of pride to all of us. Last year we were ranked 407. Prior to that we were ranked 521. So 521 to 407 and 407 to 328, 110 and about 110 and 79 position jump, unprecedented, unheard in the history of QS World's ranking. This is the result of your hard work. Congratulations to all of you. So today we have Chief Guest, Honorable Justice Vikas Mahajan ji. On behalf of University of Delhi, I welcome you, sir. And he has been appointed as the permanent judge in Delhi High Court in 2022. Prior to that, he also worked in different capacity as an advocate. These 3 laws, when I said it, they have become reality now, and 3 laws, Indian Penal Code, Code of Criminal Procedure and Indian Evidence Act, all repealed today. You have already attended 2 sessions or 3 sessions, 1 session for every law. You know in detail, you are from Faculty of Law. Registrar Vikas Gupta ji has also explained many things. So it's a very, very difficult situation for me also, what to say, what not to say. But yes, if these laws can reduce the time of delivery of the justice system, then as a citizen of our country, I and we all will feel that work has been done. Because there is a saying that justice delayed means justice denied. So there is a time frame in these laws, and if we are able to implement, then the purpose will be fulfilled. This is very, very important. This also safeguards, greater safeguards for victims of crime, ensures speedy trials. पर सबसे बड़ी बात क्या है कि हर नागरिक को सम्मान, सुरक्षा, स्वाभिमान की रक्षा का प्रयास और सबको न्याय की समय पर गारंटी, ये ऐसी बात करते हैं. Let us see what happens, but I am very, very confident that things will improve after the correct implementation of these laws. But discussions on these laws are essential in university systems, in higher education systems, particularly the institutions which are running law courses. Because we want to understand the implications, we also want to understand the future impact of these laws. Discussion is also required. Discussion is also essential for making necessary amendments in the curriculum of the universities. So now it's our job that we have to inculcate these 3 criminal laws in our curriculum, so we have to understand and also understand the impact of such laws. As we all know, these IPC and IEA were enacted during British rule, British India, but the purpose and perspective was entirely different. Here what we expect that, here the perspective and purpose is for the welfare of Indian society. Their purpose was very different. Purpose was to rule us, purpose was to punish us, purpose was to insult us, purpose was to control us. But now, to facilitate something or to control something, both things are entirely different. And if I say about these 3 earlier British laws, they represented British oversight and ideology. Now time has come, after so many years of independence, we have to inculcate the Indian perspective, and this is an attempt which government has taken. Earlier laws were protecting the interest of the Britishers, and I don't know how many of you know, in those days there were only 1 lakh Britishers in our country at any given point of time. 1 lakh people ruled us. They insulted us with the help of these laws only. That's why this is the power of law and justice system. That's why we need our laws now. And India, we have the largest and strongest democracy of the world. Yes, but it is not only because of Indian people, but also because of rule of law. And भगवान कृष्ण ने गीता में कहा है, बहुत अच्छा कहा है, कि अहिंसा परमो धर्मः, अहिंसा परमो धर्मः, धर्म हिंसा तदैव च. तो हमको क्या पढ़ाया गया? एक लाइन हमने पढ़ी है सबको, अहिंसा परमो धर्म, अहिंसा से बड़ा कोई धर्म नहीं है, और दूसरी लाइन छोड़ दी. आपने जब दूसरी लाइन छोड़ दी तो पूरा मीनिंग उसका छोड़ दिया. उसके बाद नेक्स्ट क्या है लाइन उसमें? धर्म हिंसा तदैव च. अहिंसा मनुष्य का परम धर्म है, किंतु धर्म के लिए हिंसा करना उससे भी श्रेष्ठ काम है. ऐसा गीता में भगवान ने कहा. आधी लाइन का मतलब दूसरा हो जाता है, पूरी लाइन का मतलब दूसरा हो जाता है. और वेयर वी से कि धर्म के लिए हिंसा करना उससे भी श्रेष्ठ है. और धर्म का मतलब क्या है? धर्म का मतलब है रूल ऑफ लॉ. रूल ऑफ लॉ, धर्म ही है न्याय, और धर्म ही है न्याय की व्यवस्था. अगर ये 3 लॉज उसको एस्टैब्लिश करेंगे तो पर्पस फुलफिल होगा, ऐसा मैं मानता हूँ, बहुत सारे लोग मानते हैं. न्यू थिंग्स हैव डन, कम्युनिटी सर्विसेज, introduction of terrorist act, inclusion of lynching, trial of fugitive in absentia, and many terminologies have been established. Removed, like Provincial Act, British India Act, etc. Honorable Vice Chancellor, Honorable Prime Minister of our country, he has taken a sankalp of Viksit Bharat by 2047. It means what? Our economy will be strong. In next 20-25 years, our economy will be very, very strong. But if we do not have strong legal system, justice system, and justice system of 21st century, then there may be chaos in the system. That's why one side economy, second we should have a strong deliverable justice system, and rule of law will provide us confidence and protection to every citizen. Or when I say that every citizen, सबके अपने अपने संघर्ष हैं, सबके अपने अपने समस्याएं हैं, सबकी अपनी अपनी परेशानियां हैं और सबकी अपनी अपनी सक्सेस स्टोरीज हैं. इसीलिए आई वुड लाइक टू कोट अर्जुन सिसोदिया की फ्यू लाइंस कि युद्ध नहीं जिनके जीवन में, युद्ध नहीं जिनके जीवन में वे भी बहुत अभागे होंगे, युद्ध नहीं जिनके जीवन में वो भी बहुत अभागे होंगे, या तो प्रण को तोड़ा होगा या फिर रण से भागे होंगे, या तो प्रण को तोड़ा होगा या फिर रण से भागे होंगे. आपको न प्रण तोड़ना है न रण से भागना है, और जो भी संघर्ष होगा ना वो आपको देश के हित में करना है. ये देश भी आपसे अपेक्षा रखता है. एंड व्हेन वी से वी विल बी ए डेवलप्ड country by 2047, our responsibility is bigger, our responsibility is very higher, and particularly in the educational institutions. We should understand and make necessary changes in our curriculum and implement them correctly, so that there should not be any difference in the perspective and understanding. But I am quite hopeful that this awareness program will provide foundation for taking such steps. And I would like to thank Dean Faculty of Law, Professor Ratnabali, Professor Rajni, and other faculty for organizing this awareness program. This is only a first step. We will keep on organizing such programs, not only for teachers, students, but also for the citizens of Delhi, so that they should also understand the implication and impact of these 3 laws. Thank you very much.
Thank you, sir. It is an honor for University of Delhi as we have with us a stalwart from the field of law, our chief guest, Honorable Mr. Justice Vikas Mahajan Ji, Judge, Delhi High Court. He has been working tirelessly to ensure justice for all. He has even gone beyond the call of his duty to ensure reduction in pendency of cases, especially those requiring urgent attention. He literally burns the midnight oil because he listens to cases way beyond the official hours, because justice delayed is justice denied. I request, sir, to kindly enlighten us on the new criminal laws.
Respected Vice Chancellor, Professor Yogesh Singh, Dean Faculty Law, Professor Anju Wali Tikku, Professor K. Ratnabali, Dean Academic Affairs, the Registrar, Dr. Vikas Gupta, Dr. Mridula Bhatia, Professor Rajni Abhi, Professor Balram Pani, Dean of Colleges, and Mr. Sanjay Jain, Senior Advocate and former Additional Solicitor General of India. First of all, congratulations to all of you on completion of 100 years of Faculty of Law. It is indeed an honor and pleasure to be part of the centenary celebrations. Though my education is not of Delhi, but I have heard good things about Faculty of Law, its professors, its students. Undoubtedly, it is one of the best faculty of law in the entire country. It is my good fortune that I have been invited to Faculty of Law during the centenary celebrations, and that too as a speaker. Judges rarely get chance to speak. 4:30 बजे तक कोर्ट में बैठो, सुनो, और शाम को घर जाओ और फिर सुनो. Now, coming to the topic, सबसे मुश्किल काम है पढ़े लिखे को पढ़ाना, और उनमें से भी कुछ भावी वकील जो आगे चल के दुनिया को पढ़ाने वाले हैं. So whatever time I could get to examine the new laws, I found that major changes are in the procedural laws as compared to other two enactments. New procedural laws have been enacted through Bharatiya Nagarik Suraksha Sanhita, which has replaced Criminal Procedure Code 1973. There is a major change in the provision of remand. So the dispute earlier was going on, there was already a debate going on whether the remand, especially the police remand, which was provided under 167 for a period of 15 days, would be during the initial stage of that remand period of 60 days or 90 days, which is provided under 167, or it has to be in different parts spread over that period. CBI versus Anupam J. Kulkarni was one case of Supreme Court in 1992, in which it was held that 15 days police remand could be granted only during the first 15 days. And this decision was also endorsed by a 3-judge bench of the Supreme Court in Budh Singh versus State of Punjab. However, later on, a 2-judge bench in CBI versus Vikas Mishra, this was a case of Lakhimpur Kheri, the Supreme Court doubted the earlier viewpoint and formulated a question. However, nothing happened on that aspect, but later on, very recently in V. Senthil Balaji, again that question was formulated whether the 15 days period of police custody, there was no doubt at all right from the beginning that the period of police custody is, maximum period is 15 days in that. But the dispute was only because, see what happens at times, a person gets arrested, people with means would get admitted himself in the hospital. So the 15 days can elapse while his admission in the hospital. So this became very pertinent. So in that background, this issue was formulated. However, now this aspect has become redundant in view of the amendment which has been, the new law which has been incorporated in the form of section 187, which is equivalent to the earlier section 167. Now it clearly says that it has to be 15 days, whole or in parts, in the first 40 days or 60 days. In case it is the remand period is 60 days, then it is going to be 40 days. It has to be 15 days during the first 40 days. It can be spread over, and similarly it can be spread over if it is during the 60 days, if it is a remand period is of 90 days, depending upon the, of course, the offense. It's 90 days in case of serious offenses which are punishable with life or 10 years, and it is 60 days if the offense is punishable with any other punishment. Now, in the remand, though there is nothing new with regard to that aspect, but there is always a question which arises whether the first day of remand is to be calculated or not. Because generally in the limitation laws or other laws, the day of judgment gets excluded while calculating the limitation period. So this issue has also been a matter of debate. So, the Supreme Court two-judge bench in Chaganti Satyanarayan versus State of Andhra Pradesh held that first day of remand is to be included. But in 1995, another two-judge bench held otherwise in State of Madhya Pradesh versus Rustam. The later view was approved by another two-judge bench in Ravi Prakash versus State of Bihar. However, ultimately the Supreme Court, after considering the divergent views, finally set at rest the controversy in ED versus Kapil Vidhavan, that is 2023 judgment, approving the view taken in Chaganti Satyanarayan and holding that the view taken in Rustam is per incuriam. The essence of this discussion is that the day on which the magistrate gives the remand, that is the first day of remand, is to be included for calculation of 60 or 90 days of remand. Another aspect which is related to remand is default bail. If the charge sheet is not filed by the police within the period prescribed, 60 or 90 as the case may be, then the person gets a right to default bail. So the question which has always been a matter of controversy is whether the application needs to be filed by the person and when his right will get defeated. In case whether his right will get defeated in case he doesn't file an application. So the Honorable Supreme Court has already taken a view that even oral application is sufficient, and even before the expiry of that period, if his application is pending, still that will be considered as an application for grant of default bail. So another related aspect is that can a magistrate grant judicial custody in the form of house arrest? Now this is a provision which has been inserted. Supreme Court in Gautam Navlakha versus National Investigation Agency, this is the decision of 2022, held that under section 167, now 187, in appropriate cases it would be open to courts to order house arrest. But now a specific provision has been incorporated nullifying this. A proviso to subsection 5 of section 187 has been added, which says that no person shall be detained otherwise than in police station if he is to be kept in police custody, or in prison under judicial custody, or a place declared as prison by the central government or by the state government. So therefore, the house arrest provision, the law which was laid down by the Honorable Supreme Court, has been nullified by this provision. Now, rights of victim was always there in the form of a victim having a right to prefer an appeal, which was probably incorporated in the year 2005, I suppose. An amendment was made in section 372 and a proviso was incorporated giving a right to the victim to prefer an appeal against the order of acquittal if some accused is acquitted. So being a victim, being a stakeholder, was afforded that right. Now there are certain new insertions which have been made. A new clause has been inserted in section 193 subsection 3, which is equivalent to section 173 of the code, which provides that the police officer has to inform the victim about the progress of the case, and that has to be done within a period of 90 days. Another provision which has been newly incorporated is section 230, which is equivalent to 207. Under section 207, the accused would have the rights to get the police report. When the challan is filed under section 173 under the erstwhile CRPC, the accused would be given the charge sheet and all the documents on which the prosecution would be relying upon. But now it has been made obligatory that the same document shall also be furnished to the victim, being a stakeholder. Another provision which I have found is that section 360, which is parallel to 321 in CRPC, provides an embargo that the prosecution shall not withdraw the case without first hearing the victim in the case. Earlier, under the earlier provision, the prosecution can withdraw the case at any stage, and the remedy which was available to the victim was to approach the High Court. Now that has been done away with. Another provision which is a new incorporation is evidence of public servants. Section 336. There was no equivalent provision to this 336. So this has been introduced with the solemn object of curtailing delay in inquiries, trials and other proceedings. Earlier, once a person, an expert who had given a report, the court would have to summon him to prove that particular report. Now, the provision has been made that any document or report prepared by a public servant, scientific expert or medical officer which is purported to be used as evidence in any inquiry, trial or other proceeding under this Sanhita, such public servant or officer who is either transferred or retired need not be called. It is his successor who has to be called, but exemption has not been given to the IU. The IU will have to be called for the said purpose. So therefore, the persons who have retired, their successors can come, and because it is only the report which is to be proved, and he is also equally an expert and can depose with regard to the report given by his predecessor. A new provision has been added in section 270, in the form of section 274, which is equivalent to 251. This is discharge in summons case. In the summons case, there is no provision for framing of charge or discharge. Here also, there is no provision made for framing of charge, but the discretion has been given to the magistrate after the accused is summoned to hear him and to release in case he finds that no case is made out against him. And that release would have the effect of discharge. This is in the form of a proviso to section 274. Substantial changes have been introduced through section 283, which is equivalent to 260 of the CRPC with regard to the summary trial. So earlier the summary trial, the magistrate had discretion to try a case by way of summary trial if the punishment for that case was for a period of 2 years. Now that period has been extended for 3 years. All those offences for which the punishment is 3 years at the discretion of the magistrate can be tried as a summary trial. Here it is also important to understand what is the difference between the summary trial and other trials, the warrant trials. There's only one judgment of Delhi High Court on this, which explained what is summary trial, that is Rajesh Kumar Agarwal versus State. This had come in 2010. In this, the explanation was given that under the summary trial, the accused has no right of silence. Whenever a charge is framed and the accused is asked to plead guilty or not guilty, he can simply say that I plead not guilty and then remain silent. But in this judgment, it was held that he cannot remain silent thereafter. He'll have to disclose his defense. Until unless he does not disclose his defense, he will not have a right to cross-examination. Though he can lead his own evidence thereafter. But for the purpose of cross-examination, for recalling the complainant and other witnesses of the complainant, he'll have to disclose his defense. So this is also subsequent to this principle has also been followed in 138 cases under the Negotiable Instruments Act. There's another major change in a provision relating to registration of FIRs, and which was section 156 in the CRPC. Now the equivalent section in the new Sanhita is section 175. In 2015, one judgment had come, Priyanka Shrivastava versus State, which said that the filing of affidavit along with the complaint, which is filed under section 200 along with section 156(3), is mandatory. Now, this has been incorporated in the form of a provision. Trial in absentia, already referred to, is one new provision which has been incorporated in the form of section 356, which had no equivalent earlier. So trial in absentia is like an ex parte proceedings in a civil suit. This was not there in the present form. Earlier it was there already under section 299, but there the evidence could be recorded in the absence of the accused, but whenever he comes back, he had a right to cross-examine. But now it would be the choice of the magistrate whether, but that provision has also been retained, 299. I'm missing on that. There's a equivalent provision which has been incorporated to 299, but this is a new provision. So this is actually another coercive measure in a way, because earlier the coercive measure was only in the form of section 82 proceedings, where under the person could be whose absconding could be declared as absconder or proclaimed offender, and thereafter attachment of the property could be done. But now even if he doesn't come, if he is sitting abroad, still the courts can proceed in absentia and can record the evidence and even punish him. Insofar as the Bharatiya Nyaya Sanhita is concerned, there are not much changes, but few changes which needs to be noted is that total number of sections from 511 have been reduced to 358. The imprisonment has been increased in total 31 offences. Fines have also been increased for a total of 83 offences. Then mandatory minimum punishment has been introduced for 23 offences. The community service as punishment is a new introduction which has been incorporated in section 4. For 6 offences, this punishment can be awarded. And there's one offence for which this is mandatory, otherwise it is at the discretion of the magistrate. It's the provision under which it is mandatory is section 303. Similarly, attempt to suicide has been deleted. This is in the backdrop of the Mental Health Care Act 2017 also there was a provision brought in. So therefore, keeping in view the fact that the person who commits suicide is already under a depression situation, so therefore this has been done away with. Earlier also the constitutional validity of 309 was challenged, and it was declared unconstitutional, and then again it was restored. So however it was continuing on the statute book. So lynching, as already referred to, has been made an offence. Causing a death by negligence is almost a similar provision equivalent to 304A. Now 106 has been introduced. Now organized crime is one provision which has been incorporated in the national legal framework. Earlier it was there in the state legislations in the form of Makoka, and in Gujarat also the similar provision is there. Then Terrorist Act has been included, sedition has been deleted, snatching has been made a separate offence, though it was earlier part of theft. In the Evidence Act, the Sakshya Adhiniyam, there are also not much changes except that some provisions have been clubbed. I'll just give the idea of that. So it's worth noting that Section 65B, which is a secondary evidence in the form of electronic records. Earlier, the certificate was required by the person who was having the charge of the system. But now the 2 certificates would be required under Section 63, which is equivalent to earlier Section 65B of the Indian Evidence Act. Though the certificate, apart from the in charge of the computer, an expert's certificate would also be required. Section 22 has been incorporated. It is basically clubbing Section 24, 28 and 29 of the Indian Evidence Act. Likewise, Section 23 is a combination of Section 25, 26 and 27 of the Indian Evidence Act. So basically, these are the provisions which I wanted to share with you. I am sure in the earlier sessions, Mr. Mohit Mathur and Mr. Sanjay Jain and Professor Rajni Abhi and other speakers, out of their vast experience, must have given a deep insight into the new laws. If I had the occasion to hear them, it would have made my task easier by just saying that I agree. And digressing a little from the topic, I just wish to share a few thoughts since some of the students are also present here. I have been in the criminal roster for 1 year. the criminal law is not too complex. And in the early part of your career, the chances of getting briefs are more in the criminal cases. There is too much litigation, except for the white collar crimes or economic offenses in which the clients prefer to go to the big names and the law firms. The field is wide open. So you must try your hands at criminal law as well during the initial years of practice as a lawyer. But my advice would be that in the criminal law there are certain things which you should not resort to. Don't go for shortcuts. It's small world and the reputation circulates very fast. Drive carefully and intelligently and reach the goal safely. That should be the mantra. For those who resort to shortcuts, poet Akbar Allahabadi has said in a sarcastic tinge, खुदा महफूज रखे आपको तीनों बलाओं से, वकीलों से, हकीमों से और हसीनों की निगाहों से. That was on the lighter side. बहुत बहुत धन्यवाद.
Thank you very much, sir. The last one was really something to take home. I request Professor K. Ratnavali, Dean, Academic Affairs, University of Delhi, to kindly propose the vote of thanks.
Thank you, Dr. Madura. Namaskar. Honorable Mr. Justice Vikas Mahajan, Judge, Delhi High Court, Professor Yogesh Singh, Vice Chancellor, University of Delhi, Professor Balram Pani, Dean of Colleges, Dr. Vikas Gupta, Registrar, Professor Anju Tikku, Dean Faculty of Law, Professor Rajni Abbi, Proctor, University of Delhi. Then we have Sri Sanjay Jainji, former ASG, Finance Officer, Professor Alka Chawla, Professor Anupam Jha, then we have Professor Pushpa Kumar, Professor Rupam Kapoor, faculty members, officers and officials of the university, other staff, students and all participants who are watching this event live. It's indeed an honor and privilege to propose a vote of thanks today in this valedictory session, when we are celebrating the 100 years of Faculty of Law. We recently celebrated the 100 years of University of Delhi, and we also had celebrated 75 years of independence. Now we are celebrating 75 years of the Indian Constitution, and we are in the Amrit Kal and moving towards making Bharat Viksit by 2047. At this backdrop, the 3 new laws have come, 3 new criminal laws, and since 2 p.m. today, we had various sessions which had discussed in detail. We had 1 academician and 1 advocate, so that they can give the theoretical and practical side of the changes that are being brought about by the 3 new laws. So I'm very, very thankful to all the resource persons who have given their time and effort towards enlightening all of us regarding the new changes that have come. I would like to just point out 2-3 things. When we see that a parent is trying to, guide a child, nurture a child, the approach is so very different. So very different from a person who is trying to discipline the child with an aim to extract the best out of that particular child, extract as much as possible. So that exactly, I feel, is a difference between a law made by a colonial ruler and a law made by a government for its people. So I think changing in perspective, even though the act and how you are dealing it may be, quite similar at times, but I think perspective makes it all the difference, because after all, it is a perspective which is going to come to the fore when we talk about interpreting the law and implementing the law. Second thing which I would like to highlight is also that when we talk about crimes in society, I feel that society and crimes are not disconnected. In a way, they are reflections of our society. If our value systems goes down, it is but obvious that crimes will increase. So therefore, I think that since society also has a role to play in the doing of many of the crimes, so I feel that bringing in the restorative justice aspect is very, very important, because it's not about, punishing every time, but we also recognize that this is also a evil, I would say, a fruit which may be bitter to taste, but still we have to find a solution towards such kind of acts. Third thing which we have seen is that, generally we talk about speedy trial, the spirit of speedy trial being embedded in the right to life, Article 21 of our Constitution. But with the new procedural laws, one can see that since timelines are being kept for different process in the criminal justice system, speedy trial has now become kind of systematized in the criminal justice system. Fourth thing which I would like to point out is that society is dynamic. Society is never, never static. So that means when there is a societal change, it is but imperative for the law also to change. So we can see that with technology, there are so many things happening. And I would like to share with you one episode of crime investigation that used to come in Discovery Channel, where there was a rape of a woman, and she was killed. There was no eyewitness except near the crime scene there was a chewing gum. Now, this particular, the suspect is a habitual, person who chews chewing gum, and through the, imprints of his teeth in that chewing gum, which is found in that crime scene area, the investigation collaborated that particular evidence, and that particular person was caught and punished. So I think forensic science is something which is going to play a very, very important role in recognizing its significance as well as making it part of the investigation system is very, very important. But at the same time, a few minutes back when we were talking about the technological advancement, we also talked about, we were concerned in fact, about the kind of, digital crimes that are happening. Those who are able to make changes more few and make certain things look like it, evidence, that is going to also play a very crucial role in doing justice, because people can misuse it. So I think there needs to be a balance between technology and the justice delivery system, because unless we do that, we can't blindly pick up and totally, put our faith in technology. So keeping all these in mind, I think that I'm sure each one of you who have been here since 2 o'clock, and I would like to express my special thanks to Professor Rajani Abhi. She was there right, before 2 o'clock. She has been there in entire sessions. She contributed as a resource person. Also, thank you, ma'am, and all the other faculty members who are here, and students, for trying to learn whatever they could from today's session. So let me come to the formal part of it. My special thanks to Honorable Justice Vikas Mahajanji for taking out time, sparing his valuable time and coming here to join us in this celebration, as well celebration in terms of the centenary year of Faculty of Law, as well as celebrating that we are having our indigenous 3 laws coming into effect today. At such a short notice, sir has accepted our invitation. So very thankful to you. And I also thank you for taking us through very patiently all the through the procedural laws, citing relevant cases to explain each of the concept which sir has taken us through. Thank you so very much. I thank our Honorable Vice Chancellor, our dynamic leader, who I would say is the radar of the ship called the University of Delhi, for being a constant guiding light for all of us. And sir has very rightly pointed out the significance of the 3 new laws, the need to understand the impact of these 3 laws, as well as sir has emphasized upon the need to contextualize our existing laws. Thank you, sir, for your kind words of inspiration, as well as the insights you have put into, in spite of not being a law person. Thank you so much, sir. I would also like to thank our Dean of Colleges, Professor Balram Pani ji, for the constant support he gives us. Sir is an epitome of, I would say, patience. And in spite of his, if you have seen, Sir joined little late because he is so very occupied with many other priorities. But thank you, sir, for being here with us and supporting us with your presence. I would like to thank our registrar for the guidance and trust reposed in us, because sir said 2 ही हफ्ते का टाइम मिला था हमको ऑर्गेनाइज करने के लिए. सर ने कहा जैसे ठीक लगे आप कर लो. It's so he gave Anju Tikku madam and me the freedom to invite people, design the sessions and so on. So thank you, sir. And also for the welcome address, I think you really set the tone for today's session by your very insightful welcome address, because you took us through many of the new things that are happening through these 3 new laws. I would like to thank our Dean Faculty of Law, Professor Anju Tikku, for steering the organization of this program and for delivering the introductory remarks. Thanks to all the resource persons. I would not read out the names because Anju Tikku madam has already read out in her introductory remarks. And I would like to thank Proctor madam for the support, active participation, and also for acting as a resource person. Our finance officer for providing the necessary approval to conduct this program, giving the financial support. Mr. Sandeep, General Branch, and the whole team, which has enabled the holding of this, even in terms of the, whatever you are seeing is all because of procurement. And so therefore I thank him, and Professor Sanjeev and his team for providing the photographic, videography, live streaming, and LED wall support. I would like to thank Secretary Garden Committee, Professor Rupam Kapoor, for the green and very refreshing decoration that you see in front. And I would like to thank Engineering Branch and the entire team for making it, everything working here so that we could have this event. The International Guest House for the refreshment and lunch. The maintenance staff, our computer, Dr. Mridula, she is always ever, helpful to conduct any program. When I say even at the last minute, so very thankful to you. And we thank the VC interns and NSS students for helping us in, a smooth conduct of this program. Thank you so very much, each one of you, for being here. Thank you.
Thank you very much, ma'am. I now request everyone to kindly rise for the national anthem.
Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachal Yamuna Ganga Uchchal Jaladhi Taranga तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request everyone to kindly join us for refreshments on the other side of the hall. Thank you very much.